Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff
Hello.
that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
Dati mihi Anglican for East Service Latino.
That's really not true.
I didn't ask you to interrupt me. Oh, for crumb's sake.
Good morning and welcome to the Court of Public Opinion. Happy Friday. We made it all the way to the weekend. And what a weekend we have in store. It's going to be absolutely amazing. That picture is just too dark. We've got to go full screen. Good morning. Welcome. It is great to be here with you this morning. I don't know why my camera is so dark. I fixed it every single day and it just keeps getting darker. Let's see. Is that better? A little bit? Now it's like washed out though.
Happy birthday. You look good.
That'll do. Good morning. It is great to have you all here. Welcome one and all. Welcome especially to Sloth Life. OG Sloth Life. Congratulations. You were first in chat today. We're going to punish you for your promptness and sentence you to internet ownership. Everything IP related worldwide. It's now your responsibility. Before we do the birthday thing and before we go to court, which we will, before we do that, let me just tell you, I have to update you on garlic. The question, special case says, how's the garlic breath? I have to update you. If you missed the podcast last night, in the name of science, I tried garlic. And by trying garlic, I tried a garlic clove. Raw, peeled it, popped it, chewed it, swallowed it, and I'm still regretting it. But I tried it in the name of science because scientists said, it can help. It has all these health benefits. And one of them, believe it or not, they said was it's better for your breath. Now, I found that hard to believe, but we did it. And then, of course, I had to test it. And the only way to do that is as a blind test, meaning I couldn't go up to Mrs. R.A. and say, hey, honey, smell my breath. Is what good? No good ever happens after smell my breath, right? You can't start a conversation like that. And so I just sort of laid low for a few minutes, and we were talking in the kitchen, and I just went in for a quick kiss, because what better way to get a true reaction than just surprise her with hello, I just ate garlic. That kiss was the fastest kiss I have ever had. You would need an Olympic stopwatch and possibly a high-speed camera to actually clock and measure how long it lasted. Because as I was going in for it, the alarm bells went off. I don't know if she smelled something or if somebody had told her something, but I have not had a kiss that bad since my very first kiss, which I have not spoken about publicly until now. First kiss, not with Mrs. R.A. I must admit, this was the girl I was dating at the time. We had actually talked about, maybe this was our mistake. We had talked about having our first kiss before we did it. And so the days come, here we are, we're going to have our first kiss. And I had prepared. I had practiced in the mirror. I'd listened to all the wrong advice. They're like, kiss the hand and then the girl and everything. I'd listened to everything, right? And I promptly forgot it all. But I had envisioned in my mind how this would go, and it would be absolute bliss. Clearly, you've watched TV, right? Kissing's amazing. So in my head, I'm amazing. I'm an amazing kisser. So that's the problem. I was in my head a little bit too much. I closed my eyes, pucker up, and leaned in for the kiss. Probably leaned in too quickly. It was more forceful than I probably should have been. Little did I know she had done the same thing. Also closed her eyes, puckered up, and leaned in for the kiss. And me, in my head, I'm Clark Gable in Gone with the Wind. Okay, it was just like, it's going to be amazing. It's going to be amazing. We missed. And one of us ended up with a black eye. The other one had a wet willy. And to that was the end of our relationship. We broke up. There's no recovering from that. There was no recovering from that. Anyway, Mrs. R.A. Sorry. It was the injuries were sustained were more prone to something you might see in a car accident than an accidental kiss, the miss of a kiss. But anyway, that happened. So just for your information, if you were trying to do the garlic for fresh breath thing, it does not work. I now need a new toothbrush. We've used all the toothpaste in the upstairs bathroom, and it's not good. It's not good. The science, I think it was from the Onion News or something. I don't know. It's just not there. So anyway, happy Friday to you. It's a great day. You came in just in time for a wet willy. Just so everyone's clear, the way I understand a wet willy is like the wet finger in the ear type thing. That's just putting it out. Okay, let's go straight to the birthdays because we're already in trouble conversation-wise. We have to celebrate birthdays for Amy Flo, Emily, Emma May, Haiku, Josie, Loopy Last 72, Marciana, and Zoe. That's a two-verser, so I'm going to need your help. Everyone stand up wherever you are. Take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. Got a lot of people to sing to. We're going to break it in half. We'll see how far we get. But everyone, join with me. Happy birthday to you. Happy birthday to you. Happy birthday, dear Amy, Flo, Emily, Emma May, Haiku, and Josie. Happy birthday to you. Second verse, we get to sing to Loopy Last 72, Marciana, and Zoe.
Happy birthday. You look good.
I'm trying not to think about that first kiss. Happy birthday to you. Happy birthday to you. Happy birthday to Loopy Last 72, Marciana, and Zoe. Happy birthday to you. There we go. All the birthdays properly sung to, which is wonderful. Amy, Flo, Emily, Emma May, Haiku, Josie, Loopy Last 72, Marciana, and Zoe. There are many wonderful days, but today is your special day. And I realize there are a million places you could have been, and a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy, that is ours. And hopefully we can turn some of that back to you, make your day just a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Woo! I think Mrs. R.A. forgave me because she did allow me to give her a kiss this morning. Just for the record, so you know. Although I did have to wait till she was asleep to sneak up to the bedroom to sleep on the bed. I think she was planning on me staying on the couch. So, it's all good. Tell you, you can do better than mine. You don't have to repeat my mistakes.
Happy birthday. You look good.
Drum solo for the finish. Beautiful. Beautiful. All right. Wonderful. That Willie will get clipped. Yes, thank you. Let's see. Marciana says, thank you for the song. First time in 3 years, I was here live on my day. Marciana, I'm so glad we got to sing to you. Happy, happy birthday. And also for your birthday, Marciana, I bring you closing arguments. Yes, we are expecting closing arguments. That is because if you missed it, if you fell asleep, or if you had to work yesterday and weren't able to catch up on the show, in the Brian Walshe case, the state has rested. The defense also rested. They did not call any witnesses. Brian did not take the stand. And we're going straight to closing arguments, which means that the burden rests solely, as it always has, on the state's shoulders, and they are the only people who have spoken to the jury about what they should consider when making this decision. The defense will get to make a closing argument, but they're going to be limited to using the evidence that came in during trial. Lucky for them, one of the state's witnesses did mention briefly in passing that it's possible for people to die suddenly without any, precursor indicator. And they are going to bet their whole farm on that statement. So we're going to hear that this afternoon. They have 45 minutes each to speak to us, and it's going to be good. It just sucks that we don't get to hear from Michael Proctor. I was hoping to have Mr. Proctor on the stand one more time, to maybe get some clarity on why he did what he did. I'm going to count what Willie comments in chat today. I'm sorry. I shouldn't start it, right? I shouldn't be the one that kicks off the headache for the mods. But it is Friday. Hopefully y'all are having a wonderful, wonderful weekend ahead of you. Let's see. We're going to hear that BS for 42 of the 45 minutes. I'm looking forward to it. The defense put so much pretrial effort into the Proctor issue, while it never materialized. I think had Brian testified, they would have called him. But since he didn't testify, they really didn't have a foundation for anything else that they wanted to bring forward. All the experts about sudden unexplained death and everything else, there really was no foundation for that. There was no explanation. There was no evidence presented to the jury that that's in fact what happened to her. And so, they had nothing. And if they only brought in Michael Proctor to say, yeah, I was fired because I didn't do my job the way I was supposed to. I did some bad things. That does not absolve you of murder, Mr. Bryan. If the jury's thinking you're guilty of murder, Michael Proctor being involved in the case does not make it not have happened. And I think they knew that they had very limited mileage they would get from that. All right. The sudden unexplained death thing reminds me of a wise modern-day philosopher once said, yeah, and monkeys would fly out of my mind. Okay, I should read the whole comment before I start reading it out loud. Friday verdict music, the very, very real possibility. This jury will be most likely deliberating by lunchtime. So we're starting at 9. 10, 11 takes us, with the two closings. They're 45 minutes each, but that gives an extra half hour for whatever we need to. That covers the break. Then we have an hour for jury instructions. I think lunchtime, go forth, eat your sandwich, and deliberate is what we're going to see in this one. Gracefully Broken Mom, member for 9 months, has been here longer than 9 months, but we'll go with it. I've still got those garlic burps. I was around Daryl Brooks, but lost your channel. Thanks for all you do. I'm so glad you're back, Gracefully Broken Mom. I can tell you, going back to the garlic thing, my stomach is still not liking the garlic. It was like last night, I was like popping Tums like they were candies. I'm just like, ugh, it feels like I ate half the ingredients to a salsa. That's the stomach feel you get when you eat a clove of garlic raw. So unless you have a tough constitution, I don't recommend it. Wait a second, are we really on day 10? I have day 8 for today in my notes. It should be day 10. Yesterday was day 9. Let me look at my notes. Let's see. Brian Walshe. Huh. Yeah, day 9 they rested. That's all that happened. So remember, nothing happened the other day, right? That's why we had a short day and they did just jury instructions. Okay, the judge is here. Let's hear if we can listen in a little bit as we're getting ready. Right on time, 9 o'clock. Good job, Judge. Appreciate your promptness. Not hearing a thing, though. Waiting for audio.
For the Commonwealth versus Brian Walshe, criminal indictment 2023-0091. Matter continues on jury trial. Counsel's present in court. Counsel starting with the Commonwealth. Kindly identify yourselves once again for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning, Counsel.
Good morning, Your Honor. Ann Yas for the Commonwealth.
Good morning.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning.
Good morning, Your Honor. Good morning, everyone. Kelly Porter on behalf of Mr. Walshe.
Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walshe.
Good morning.
Larry's going to be doing the
wait
closing.
For Mr. Walshe, but while we're waiting, I'm just going to pass you out a couple of versions of something I want you to look at. I have a preference.
The record reflects Mr. Walsh is now present.
I don't know how many copies that is, but I think it might be enough. If we need more,
You can share.
I have more. I just put that to the side, council, until we get there.
Kelly H., thanks for the super sticker this morning. Amanda H. gifted 5 memberships. Donna Littlefield, congratulations on 4 months. Thank you very much. And Gracefully Broken Mom, 9 months plus.
All right.
Thank you.
Good morning,
Appreciate
Mr. Walsh. I said good morning to everybody else, so good morning to you, too.
Morning, thank you.
So since the version that I sent you at 1:55 p.m., I've made the following edits, either based on prompting by you or by my own
Sua sponte.
accord. So on page 9, the use of a dangerous weapon is out. On page 17, the stipulation, separate instruction, I incorporated that into the evidence instruction. On page, it was on page 19, so what I did is I just added into page 19 some text. It's the second sentence. The evidence consists of the testimony of the witnesses, as you recall it. And then I just added in there the things that were marked as exhibits and the stipulation/agreements of the parties, rather than have it as a separate to-do. Just making it a little bit more streamlined. I edited out the last sentence of graphic photos instruction on page, I think it goes to the top of full page 18 as irrelevant to this case. And I also have removed the separate section later on page 18 about opinion testimony as repetitive of the expert testimony section above. On page...
The jury sounds jovial in the hallway. Note just came into the judge.
Old page.
It was for the clerk. Just hammer down the last details of the jury instructions here.
Now I can't find it right away. You may know where it is when you read through it. It says you'll have all the evidence with you.
You won't actually have all the evidence.
I removed the non-relevant weapon and put in including the tools. But as I was thinking about that last night, mental note was, what does the Commonwealth, or how does the Commonwealth intend to safely put those tools? So what I've done in other places, or what I've seen done in other places, and it most often comes up in the context of a knife going back. I've seen other DA's offices basically take the knife and it's like they put it on a hard board and then they strap it down.
We don't have time to do that.
So the jury can see the item but can't hurt themselves unwittingly with the item.
Or wittingly.
It seems that the same could be done of the tools in this case, if you have the capability to do that. I think I've seen that done in Middlesex, Plymouth. That's how they sort of handle the issue. How are you planning on handling it?
Just give them
We're working on it this morning, though.
Okay.
They can
So
pick up everything
what I have
from
in my
Home Depot.
mind, just so that, and I think law enforcement in the past has done it for the DA's office, so they may have the strapping mechanisms. But as long as I'm assured that they can go in safely to the jury deliberation room, either with a sheath cover on it or preferably strapped down to a hard board. It seems to me that that would be a good approach. Anybody object to that?
I do, because they can
No,
only
Your
see
Honor.
one side.
We'll work with defense counsel, but we're trying to get some supplies to do that this morning.
All right.
They should be able to examine the evidence, not just look at one side, the side that's presented to them.
So I passed out to you.
Thank you very much.
Two versions. I went back to look at different instructions I have. I looked at a few different things, and this relates to the direct and indirect evidence instruction. And the version 1 is what I will call I put this in air quotes, I'll call it the Superior Court version of or what I most often see in the Superior Court, which is different than the District Court version, which is a little clunkier, I think. But anyway, you always like what you like, right? That is probably the more traditional, old-fashioned perhaps. As I read through it last night, I think it reads better than the version that I put into the first draft, but I don't have strong feelings about it. So if we have agreement between the parties as to which one you like better, I'm happy to read that. I think both of them are accurate representations of the law. I have a preference for version 1. Take a look at that and let me know when you've finished looking at them and have an opinion.
When you're done reading, look up. Yesterday we did we covered a case out of Utah that had some media implications, media coverage implications. I can't go over all of it, Cass, unfortunately, right now, but basically the judge has to make a ruling. It looks like, for the most part, both sides recognize the media has an interest in the case. The state is okay with the media being listed as a party in a small p on the case, and the defense does not want them there. Defense is eventually working towards the motion, which they will be filing sometime next year, to exclude cameras from the courtroom. So that's their direction they're heading. The state is not. The state recognizes the challenge there and does want the gag order. The gag order was approved. It was modified a little bit.
Your
but
Honor,
basically
the Commonwealth doesn't take a
can't
position.
witness,
Either
can't
one
talk.
seems
fine.
And neither can the
Normally,
the lawyers.
honestly, I don't spend a lot of time on this in most cases but this case is one that I spent a little more time on it. Yes, Attorney Porges.
Your Honor, we're requesting version 2. So if no one else has a position, I'd ask the court to read that.
There you go.
Right, which is my version 1, I guess, right? It's the version that was in the instructions yesterday.
I believe so.
All right. Both are correct recitations of the law, so if you wish to draw from any of them, they're all good. And I'm not sure that they make a huge difference. All right. Any other edits to the draft instructions beyond those that I've just incorporated?
Your Honor, on page 12 of the 155 instruction on reaching a verdict, I believe there's some references for each charge, and I would suggest that that might have been a carryover, the plural version.
The four-person?
I have page 12, reaching a verdict, the third paragraph for each charge.
For each charge.
For
That means
the
lesser
charge, yeah.
included.
And
Okay.
then has proved every element of the charge beyond a reasonable doubt, then you should find that Mr. Walsh is guilty of the charge or just is guilty.
That means no lesser included.
Okay.
In the next paragraph,
And same thing, particular?
yes, Your Honor, particular and then the on that charge.
I'll just end it at not guilty.
Your Honor, on page 13, role of the jury, second paragraph. Do not be influenced by the nature of the,
Charge?
yes, Your Honor.
They're making it singular.
I think I already made that change. I just didn't tell you I did.
Your Honor, on page 31, alternate jurors, I believe there's a reference to 3, and I believe it's 4.
It is. I made that change later in the day, too, and I didn't tell you about that either.
That's all the Commonwealth has identified, Your Honor. Thank you.
Usually we find more mistakes while reading it to the jury, but it's all right. Defense?
Anything additional from the defense?
No, Your Honor, content, except for the previous exceptions made.
Anything else before we call the jury out and get
Well,
the show
now
on the
I
road?
think most of the previous exceptions you made have been removed,
Just being cautious.
but I get the point.
Can't think of anything, but I'd like to
All right,
preserve
let
the
me
record in case I
step
did.
off the bench quickly and make these changes. And the reason for that is I want you to each have a all to have a copy so that you can follow along while I'm doing it. It shouldn't take me very long.
All right.
I think she's actually the one making the changes. She's actually like going to her computer and typing them in, which is great. All right, a couple things we can go over. First of all, it took the judge talking about the evidence yesterday to get me to the point where I am today. But I want to tell you that right now, if I was a member of the jury, I would vote guilty on murder one. And it took the judge to put it together. And part of it was probably a timeline issue in my head, as there was a lot of evidence that I just hadn't placed in order to see when it happened. But the thing that really sunk in was the judge's reasoning when she said, because he bought the booties at the store. And it's reasonable to assume that he bought the booties to keep his shoes or his feet from getting bloody at the crime scene, the same reason to the Tyvek suit. It's reasonable to assume he used those because we didn't find a full package unopened of booties at the scene. But what we did have was bloody slippers, his and hers. Why would we have bloody slippers unless there was a murder scene where basically it happened while they were wearing slippers? It just makes sense. It makes sense. And I'm there now. So I'm with them. I realize there is not a lot of evidence, and it is a circumstantial piece of evidence that gets us there. But for me, that was enough. That's enough to get past the hesitation that I would have. But I appreciate the judge putting that together. I really hope, because the jury did not get that benefit. Obviously, they shouldn't from the judge. And it's okay with the judge talking with the lawyers, but the judge should never be the one that explains it in that way to the jury. I need the prosecutors to put it together. If they can give us the timeline of just the relevant details, right? Because there are a lot of details in this case that, some matter more than others. Which order he went to the dumpster after he had disposed of her body, or which dumpster he went to and what they think they put in it, not as important as what happened before. That is crucial. And if they can get that in on closing arguments in 45 minutes, I think this will be an open and shut case. Yeah, good stuff. All right. It is total circumstantial. Well, aside from, the tools and things like that, we have some physical evidence, DNA, all that. All right. What got me to murder one was the searches for the insurance payout after death a week before the murder. Mog, I don't remember that. I thought that was after. I thought that was after the murder. Let's see. December 27th, he did some divorce searches. 29th, he researched Anna's work history. Christmas, he looked up the boyfriend. But it was January 1st that he started best way to dispose of a body, how long for someone missing to inherit. That, yeah, I show it's January 1st, which would be after. I don't think that was a before search, unless I heard wrong. It might be in the notes. You guys are saying no, it was before. Well, if it was before, that's a huge additional piece of evidence. I'm sure that the Commonwealth will spell it out. All right. I think he started out with divorce searches, then slowly realized that only a murder will do. Well, divorce doesn't help him financially at all, right? Divorce, you lose half of everything. He also brought the second phone on the December 22nd. There are a couple things he did on the 22nd that I think a reasonable inference can be taken from. Specifically, I want to hear more, and I want to hear this spelled out really clearly. The phone call to his probation officer asking permission to drive on December 1st, drive his mom home or something like that, when he knew at the time that his mom would not be there, that he would not need to make that trip. That's pre-planning. That's next level. That's the anticipation, thinking it through in our head. That is premeditation all day long, if that's how it happened. From the surgery, the recovery from the surgery, right? He'd get alimony too. I don't know. He had some income, although most of it was going away. He brought a lot of debt to the relationship at this point. Do you mean January 1st? I did mean January 1st. What did I say? December? For me, I see the searches for divorce that he obviously didn't like the answers from that. He found out that Massachusetts was not the best state for divorce. And then moves to murder and dismemberment. There's progression of actions there. Prosecution's timeline was all over the place. That's why they gave the jury blank calendars. Yes, they did. And the jury does each have a calendar that hopefully they've been using. And maybe the jury's already there because they used their calendar and filled in the slots and the times as it went along. I said January 1st. I said the wrong thing. I apologize. He also had plans with Anna on the 1st. Anna had plans. She had flights and everything. There were plans all over the place. But I think one of them knew that only one of the plans was going to happen. I think Christmas made him very angry and he wanted to go off on her then, but she didn't show up. So January 1st it was premeditated to me. I know she was there the whole time between Christmas. She spent that week. They would spend that week together. The calling a friend the week before saying she's missing lays the foundation of, oh, she's gone again. These things happen. She's gone. Don't know where she is. Clearly not dead because there's no evidence of a body at my house. I see that now, Sarah. I can be with you on that one. Let's see. I think he lied to the probation officer to take Anna out. I agree. I just checked the inheritance search was on January 1st. Katrina, thank you. I'm glad I remember that correctly. I think that's what I had in my notes anyway, so I can trust my notes at this point. January 1st, 4:54 a.m. Best way to dispose of a body. January 1st, 6:24 a.m. How long for someone to inherit? Can you throw away body parts? 9:30. How long does DNA last? Is it possible to clean DNA off a knife? January 2nd. How long does Lowe's keep security footage? No worries. We're all here to help each other. So, what evidence do we have that she was actually murdered? CDG. The bloody slippers. Her bloody slippers. His bloody slippers. They got ready for bed. I think that part of the story is true. But I don't think she ever made it to bed. The knife, the bloody slippers. He went to the trash once before he started his searches, I think. Before he went to the stores, there was a trip to the trash. That could have been from dismemberment, though. I don't think so, because of the booties. He bought the booties. All the tools that he had for dismemberment, and why would he wear her slippers and his slippers in the crime scene? That doesn't make sense. He didn't have the tools for dismemberment until he had gone to Lowe's and Home Depot. And he had those booties for the Tyvek booties. $30 months for me. Woohoo, I joined your channel now. I live here now. That makes you an OG. Congratulations. If his slippers were bloody in the action of murder, where is the evidence of it in the house? Hey, well, we did watch the same trial, right? We literally watched him haul off bags and bags of evidence. We assume body parts were in there as well, but there's blood in the house. There's Anna's DNA, blood DNA in the house. He got 18 bottles of hydrochloric, or not hydrochloric acid, of the spray bottles, the ones he stole from CVS, remember? That was the cleanup. He bought the bleach. He's got 24 pounds of baking soda. The cleanups, you can't say you get away with murder because you cleaned it well. You didn't get it all. Ayden Reese sent 5 memberships. Thank you very much, Ayden. Appreciate your generosity. Good morning to you. Thank you. That's generous. The rug is the evidence for sure. That's it. Gretchen Lee, I'm still recovering from a migraine, but I'm here for this. I'm sorry. I'll be a little quieter. No, I won't. I'm sorry. You're going to have to turn your volume down. I only have one volume here. What's with the hole in the ceiling? Tadachus, I think that's a red herring. I think it was completely unrelated to this crime. I think that's a home improvement project, a light change, an idea. They wanted to do something. Maybe they had a rat or something, or a squirrel that got in the insulator. I don't know what it is. I think that does not fit at all with the murder. It just doesn't fit in there because the puzzle pieces that fit up in the ceiling were in the drawer of the dresser. If they were thrown away, I'd say, okay, there might be reason. There might be blood on there. He might have, like, in the stabbing motion, lost control of the knife, and the knife stuck up in the ceiling, and now there's blood everywhere. There could have been something like that, but no. I think it was peroxide, right? Hydrogen peroxide. Who wakes up to the dead spouse and doesn't call 911? Instead of calling, decides to chop them up. It speaks to a guilty mind. I think the consciousness of guilt argument is strong in this one. Did anything ever come out of the insulation that the police removed for testing? No, nothing at all. Yeah, the piece of ceiling was intentional. It was cut out, but I don't think it had to do with the crime. Unless it would just be speculation. Unless Brian was trying to think of a way to make it look like it was an accident. Oh no, a piece of ceiling fell down on her head. And she died. I don't know. It could be some twisted idea in Brian's head of how that would help, but he saved the pieces. So you saw what he did with everything else associated with the dismemberment and the murder or any evidence that might point to that. All of it got disposed of. I don't think he would have saved that. So I don't think it's related. If there had been blood on the ceiling, there would have been blood on the walls. I agree. There would have been a lot more evidence, and there was none up there, aside from the rug in the front room. Let's see. We don't have Anna's phone. That was one that was not recovered. Judge is taking a minute here. The break this morning is for the judge to finalize the jury instructions, and she's going to print out a copy for everybody so they can follow along as she reads them. We are still waiting. We are still waiting for confirmation as to whether there are lesser includeds in this case. We know that legally they can be there in Massachusetts. We saw this in Karen Reed's trial, the lesser includeds. But the way they keep speaking about the charge instead of charges, there is only one charge, but there still might be multiple possible verdicts they can reach from that charge. So we're basically going to be sitting on pins and needles waiting for the judge to read the verdict form for us to know exactly what the jury gets to decide and what their options are. Do you think he asphyxiated her or smothered her? Lorby, I think it was the knife, and the booties got me there. The bloody slippers got me there. I think that blood on those slippers was from the murder and not from the cleanup of the murder, so to speak, from the dismembering. Let's see. Brian Walshe did read 11 pages of an article about how to dispose of a body. He read a lot about that. Is the judge printing us a copy? No, she neglects to do that every time for some reason. Does anyone think that Brian Walsh's mom has Anna's ring? I think it's a fake. Is that wrong of me? I think it's a fake ring. They were too strapped for money at the time that ring came in to have it be a couple $100,000 ring and have it be real. Their financial situation was tight. They were barely, even with her great income, they were barely making it by. So unless there's a K Jewelers big huge loan out there on a ring, I just don't see it, and that would have come in. Diamonds are expensive. Yes. It's a pawn shop special. Can you imagine RA on a jury? I can't. I don't think I'll ever get there now because of my interest in true crime. I think if I get asked the right question, I will be eliminated in a heartbeat. What are we waiting for? The judge is finishing up jury instructions and printing them off. It should just be about 5 or 10 minutes. When I saw that rock, I said, no way, it's real. Yeah, rocks that big are typically named, like the Hope Diamond and things like that. It was a huge, huge stone. It could have been lab created, which would have made it cheaper, but still, it's not. I don't see them having $100,000 or a $200,000 ring that's just like, oh, and I got her a ring, just because Happy Wednesday. Do we know how many buckets were recovered in the end? Because he bought many of those. Music addicts. Sorry. I think we know that there were some Lowe's buckets that were still left over in the basement. I don't think we found any Home Depot buckets left over. Okay, it looks like Judge is coming back right now.
You are unmuted.
Please.
You look at Judge's desk, she's got a stubby little pencil protruding over the top of the bar. Yes, I would need a break for a nap.
Everyone all set? Good.
Bring the jury.
All right.
About to catch her whooping.
I just made the sounds work again. Sorry, I realized they were turned off. Yes. She has ordered her chair. I've put the ones that were acceptable that she might choose from in the shopping cart. She's chosen one and ordered it. So her gift is on the way.
You just use your words.
Just use your words.
Hello.
Have them send someone with more experience.
Kaylee Rose, lawyer, does some great recaps on this.
There's nothing in the order that restrains you from talking to cats.
I got a stubby little pencil.
Yeah, they're all working, guys. They're all working.
All rise. Jurors entering.
Even a blind squirrel finds a nut every once in a while.
I fixed it so it works. I fixed it. I figured out how to fix the ones that cut off early. So I haven't done this yet. I should do that. All right, jury's coming in.
Hear ye, hear ye, hear ye. All persons having anything to do for the Honorable Justice Diane Frenier, Justice of the Norfolk Superior Court, draw near, give your attendance and you shall be heard. Let's have the Commonwealth of Massachusetts in this honorable court. Please be seated. Please turn up your cell phones.
Jurors, and welcome back to Northern House.
Last time we get to ask you this.
Jurors will start today, as we have every day together, with the 4 questions. Jurors, were you able to comply with my order that you not be on any social media or any news media?
Yes.
The jury is ready.
And were you able to comply with my order that you not do any research about this case?
Yes.
Did you tell them not to start deliberating? No, they probably have been deliberating.
Comply with my order that you not speak to anyone about this case?
Yes.
We did a verdict already. About 98% of us.
Yes.
98% of us are guilty, either murder 1 or murder 2. Maybe 99.
Those 4 answers for the record, all answered affirmatively by all 16 jurors in the box. We're ready to begin today's work. So as I promised yesterday, jurors, there's 2 chapters that will come interspersed now as we start today. And those chapters are that I will give you the instructions that are specific to the charge of murder here in this case. Then the parties will do their closing arguments. And then, depending on how you're doing, given the time that's passed since then, we may have a short break, a bathroom break. Then I'll come back and give you the more generalized instructions on the law. Deliberately break it into 2 chunks. It's more consumable for you that way.
All right, is she going to stand right there?
Jurors, I want to thank you for your service on this jury. To a person, when I've looked over, you caught me many times looking over at you.
That hurt.
You've been paying attention, and that's exactly what I anticipated, but it's refreshing and rewarding for me to see it. So I know that you have paid attention to the evidence in this case, and I appreciate your attention. Your jury service in this case is a very important part of our democratic self-government. You are responsible to uphold the law and our principles of justice. That's what you promised to do at the start of this trial when you took an oath as a juror. You've all devoted a substantial period of time on this case, time away from your personal lives, your work, studies, your families, to sit as jurors in this case and to decide the very important matter, an issue now between the Commonwealth and the defendant, Brian Walshe. You've done so in accordance with the finest traditions and the highest aspirations of our system of justice. Again, I thank you for your service and your sacrifice.
A lot of praise, Judge. Let's get to the chase.
You must now consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that Mr. Walshe is guilty of the crime of murder. The final part of this trial, as I said, will take place in those 3 steps. First, I'll give you on the law that is specific to the charge in this case. Then the attorneys will make their closing arguments, in which they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to make. Defense attorney, Attorney Tipton, will argue first, and the prosecutor, Assistant District Attorney Yaz, will argue last. After the closing arguments, again, I'll give you those generalized instructions that will help guide your evaluation of the evidence and your decision-making and your deliberations as jurors. And then you will work together to reach a unanimous verdict. Please pay careful attention to all of my instructions. All of my instructions are important, and you must follow them, whether you agree with them or you do not. To make sure that I give you the instructions accurately, you can see that I'm generally reading them to you. You will also get written copies of the jury charge, the jury instructions, in the jury room when you deliberate the case. I do my best to make sure that the instructions that I'm giving you while I'm speaking match these written instructions. If there is any difference between what I say aloud and the written instructions, please follow what I say aloud. So let me start with the prosecution's burden of proof, and I'll start with the presumption of innocence. There is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Mr. Walsh is presumed to be innocent of the charge in this case. That means that you must consider Mr. Walsh to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Mr. Walsh committed the crime charged. And I will explain what I mean by reasonable doubt in a minute. Mr. Walsh does not have to do anything to convince you he is innocent. He does not have to explain anything to the jury. Mr. Walsh does not have to testify, call or question witnesses, or provide any evidence at all because you must presume he is innocent. Instead, it is up to the Commonwealth to prove the charge against Mr. Walsh beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all of the evidence carefully and fairly, if you have a reasonable doubt about Mr. Walsh's guilt on the charge of murder, then your verdict must be not guilty. You may find Mr. Walsh guilty of the charge of murder only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So, the burden is on the Commonwealth to prove beyond a reasonable doubt that Mr. Walsh is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, or everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proof beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That's what I mean by proof beyond a reasonable doubt. There's one indictment or charge in this case. You must decide whether Mr. Walsh is guilty of that charge. For the charge of murder, there are certain things, we call them elements, that the Commonwealth must prove beyond a reasonable doubt to show Mr. Walsh is guilty. I will explain these legal rules to you now. There are two different degrees of murder. Murder in the first degree and murder in the second degree.
There you go.
If you find the defendant guilty of murder, you shall decide the degree of murder. Commonwealth alleges that the defendant committed murder in the first degree on a theory of deliberate premeditation. To find the defendant guilty on this theory of murder, you must be unanimous That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every element of this theory beyond a reasonable doubt. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt this theory of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I'll begin by instructing you now on the elements and the additional requirements for the proof of murder in the first degree with deliberate premeditation, and then I will next instruct you on murder in the second degree. Murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following three elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully intended to cause Anna Walsh's death. And third, the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of those requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully intended to cause Anna Walsh's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant A, intended to kill Anna Walshe, or B, intended to cause grievous bodily harm to Anna Walshe, or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. The defendant's act is the cause of death. The act, in a natural and continuous sequence, results in death, and without which death would not have occurred. As you can see, the second element has three sub-elements, which I'll call prongs. And the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Anna Walshe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. Let me give you some supplemental instructions relevant to the charge of murder. The definition of death. Death occurs when the heart has stopped long enough to result in complete and permanent loss of brain function. This complete and permanent loss of brain function occurs when, in the opinion of a licensed physician based on ordinary and acceptable standards of medical practice, there's been a total and irreversible cessation of spontaneous brain functions, and further attempts at resuscitation or continued supportive maintenance would not be successful in restoring such function. Next, the jury's obligation on guilt or innocence. You've been instructed on two theories of homicide in this case: murder in the first degree and murder in the second degree. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find him not guilty. Would either counsel need to see me?
No, Your Honor.
Be happy to see you.
The judge asks, do you need to see me? Basically saying, did I do this right? Do you have any complaints about how I've talked about this so far? I think the good news is that we were right all along. There are lesser includeds. The jury does get to decide whether it's murder 2 or murder 1. If they decide it is, in fact, murder, the one charge is murder. Jury decides the degree of murder in their verdict. So, pretty straightforward. The elements of this charge match pretty much most other states. The wording is a little bit different. The intentional premeditation, it's there on the first degree murder. Food in court somber. It's quite a serious occasion. Did you have to make a correction here?
I know you haven't been sitting there that long, but you're going to go for a stretch now. So I'm going to ask you to stand up. And, as I said to you before, shake a leg.
Shake a leg. Shake the other leg.
When you're ready, please be seated.
Happy birthday, Loopy Lass.
So, jurors, I'm about to conclude my first set of the instructions to you, and we're going to hear the closing arguments of counsel next. This is an important part of the trial because it's the final opportunity that the lawyers have to address you. It's an opportunity for the lawyers to summarize the evidence, to call your attention to certain parts of the evidence that they regard as important, and based on the evidence, to try to persuade you to reach a certain result. However, what you're about to hear is not evidence. Lawyers aren't witnesses. All of the evidence in this case has been presented to you through the testimony of the witnesses, and the exhibits, stipulations, which you have before you. And as to the exhibits, you'll have an opportunity to examine those in detail and consider them during your deliberations. Our rules are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the lawyers are not permitted to refer to facts that are not in evidence in this case. If, based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal beliefs in the credibility or lack of credibility of any witness who testified in this case. That determination is entirely for you to make. If a lawyer makes such a comment, you should disregard that comment. This case must be decided based solely on the basis of the admissible evidence and the law that I'm teaching to you. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If a lawyer makes such a comment, you should disregard that comment. If you become conscious of any passion or prejudice as you consider the evidence and engage in your deliberations, you must put these feelings aside and not permit them to influence your thinking. With that, we'll turn to the closing arguments. As is the custom, we'll hear first from the defense. Attorney Tipton.
So we're not bifurcating the closing for the state. It's just going to be one closing, but they do the last. So the state gets the final word. They do have the burden of proof. The lectern is moved. Not that Mr. Tipton's going to use it, because he likes to wander around anyway.
What could happen to a loving father and a loving husband? They're making line of police before they...
Audio was terrible.
Search for the unspeakable on the internet. Exposed body of the woman that he adored. Government suggests it was an affair. There's no proof of that. There's no proof that Brian Walsh knew anything about an affair between the woman he loved and William Pickles.
Saying what can happen to make somebody do this.
Second reason,
government says it was an affair.
The government suggests family money. Money that the family had worked together for years and continued to talk about.
It's about as loud as I can make it.
And the sales of property. Trying to protect the assets for the benefit of the whole family and the future of the three children. A motive? There's no motive. Refusal to consider prison for a terrible mistake he made. The case that began in 2018. There's no proof of that. That he was afraid to go to prison. Who wants to go to prison? But prison was always on the table. And it was just something that he had to face up to, and something that he did. So, what would cause a loving husband and a loving father to do the things that you heard about in this case? Could it be something that was sudden, something that was unexpected, something that was unbelievable?
something that only a medical examiner would understand and have knowledge of, but not a man like Brian Walsh. Something that is terrifying, something that defies logic when it happens. How do we know that Mr. Walsh was a loving father and a loving husband? We know from much of the testimony of Jim Mutlow. We know from simple testimony from Julie Basler from Kinderkind. When asked questions about her experience with Mr. Walsh and the children, that he would show up and he'd be interested and he'd be friendly, and he was always interested in the progress of his children. And how do we know he was a good father? Because Anna Walsh trusted him with their 3 children, 24 hours a day, 7 days a week, for all those times she was up in Washington, D.C. The unthinkable happens. It happens in a variety of ways. And the Commonwealth must prove to you beyond a reasonable doubt that a homicide occurred, that a killing occurred. Nothing proves that beyond a reasonable doubt on the facts and circumstances and the evidence given to you. There's evidence that he lied to the police. There's evidence that he searched the internet. There's evidence that he disposed of a body. But there is no proof in all of the evidence that you have heard and been presented that he ever once thought about harming the woman he loved. That he ever thought about harming the woman he loved. That he ever planned to harm. That he ever intended to harm. So, when we talk about the evidence of the affair, when we talk about evidence of financial concerns, when we talk about evidence of being ready to go to prison, those are the motives that the Commonwealth needs to prove to you to support any notion that a loving husband and a loving father would kill his wife. And the evidence suggests there was no motive at all. And without a motive, without a reason that is based on facts and circumstances, logic and understanding, without that, you have a sudden and unexpected event that results in confusion, and panic, and fear. All of those things that are so troubling and horrific that you've heard evidence about, they may be argued that they show consciousness of guilt. But people do things, terrible things sometimes, not out of guilt, but out of fear, out of disbelief, out of confusion. Certainly, a loving father and a loving husband would feel guilty about what he did do. Not just about lying to the police, but what he did do in the context of what he did to the woman he loved. In a moment, in hours, and in days of confusion and disbelief and horror. But that feeling of guilt had nothing to do with her killing, because he never killed Anna Walsh. you will hear arguments that you've seen the evidence that might evoke emotion. Who wouldn't feel emotional in what you've heard, what you've seen? But your obligation, and I don't mean to sound like I'm lecturing you at all. Her Honor will instruct you on the law, and that is not my province, but you cannot base your verdict on sympathy for Anna Walsh. You can't base your verdict on anger to what Mr. Walsh did. You can't base your verdict on passion based on the evidence that you've heard that is upsetting and terrifying and at times disgusting. But that's not what you can do as jurors in this case. At the beginning of this case, when you were sworn as jurors, you might not recall it, but the clerk of this court read you some words. To this indictment, the defendant pleads not guilty. He places himself before this country which you are, the obligation that you have accepted in this case is unlike perhaps any obligation that you've ever accepted in your life. Perhaps. That's for you to judge. But your obligation requires that without passion and without anger and without sympathy, that you assess the facts as troubling as they are, and at times as horrific as they are, and make your verdict rest on the evidence, and nothing less and nothing more. Unbelievable, facts that don't make sense at times, something that is incongruent. An example of that is the end of Mr. Jim Mutlow's testimony, where for almost an hour he talked beautifully about the love between these two people, that he talked glowingly about Mr. Walsh. And then toward the end of his examination, he wanted to say something about now he was thinking there might have been some kind of problem. And reflect upon the evidence that he gave.
They objected to all that.
Of a phone call he had with Mr. Walsh on the 4th, when the conversation was confusing to Mr. Mutlow. Confusing where he kept asking what could have happened that would result in Anna Walsh leaving. The lie that Mr. Walsh was telling people out of fear that no one was going to believe him about what happened, so he lied. But consider the way that Mr. Mutlow had a terrible time trying to understand that. And why? Because he knew both of them. Because what he was thinking, why would Anna Walsh leave? They love each other. I know them both. It makes no sense. And that is what happens when something happens that is totally confusing. You just can't believe it. And you seek answers. You yearn for answers that make sense of something. And when something sudden and unexpected happens, something tragic, your ability to come to terms with it, when it's such a dynamic, such a tragedy, you change. You change. The evidence of the searches. The dark, troubling evidence of the searches. They began at 4:52 a.m. on January 1st of 2023. And the first one is, how do you dispose of a body? It causes chills. It causes disgust. Look at all of those searches.
50.
Think of how they evolved. Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then the sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walshe began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's the search that occurred 6 hours later. And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context. In this case, on these facts, context matters. And so the first time the word murder is used in these horrific searches is 6 hours after they began. And I tried to ask Trooper Garino, one of the forensic specialists, as he called himself, associated with the Mass State Police. I tried to ask him, well, it's only logical, isn't it, that if you don't get results, you change the wording. We all know that from our own common experience. And you look at those searches that came and went during this time, and the results have to do with funeral parlors and cemeteries and things like that. But Mr. Walshe, given the tragedy that occurred to his wife, and given the time that had passed and his fear and disbelief, he couldn't call a funeral parlor. We need to try to understand, what can I do? Then the searches become darker. They become more upsetting. Now the thought is dismemberment. And there's searches like that. You've heard about them. You'll read about them. And then you see searches that cover days. And there's searches about cleaning. And there's searches about how to clean up. You'll read them. And even though they don't talk about murder, they are equally upsetting, because you're thinking, as jurors in this case, he's thinking about cleaning up the basement. He's thinking about how you clean a concrete floor. Context. 1,034 pages of digital data, 3,667 records taken from his MacBook. Not one record, not one page refers to any plan. Not one record, not one page refers to any intent to kill. Nothing. So keep it in context when you review that exhibit and those searches, and ask yourself, why is a man searching now if he had intended to kill his wife? Why is the man searching now if he had planned
Why is the man yelling
to
at
kill
us?
his wife? And that is the government's theory. He planned. He deliberately premeditated the plan to kill his wife. Where is the evidence of premeditation? in thousands of pages of records. I suggest to you respectfully, you are the jurors. What is the evidence of premeditation? There's evidence of a knife. There's evidence of a knife that is seen in a kitchen cabinet. Could I please have exhibit 201? And next exhibit 202. And finally exhibit 203.
Thank you, Larly Annie. Appreciate it. Thanks. Congratulations on 14 months.
It was above a refrigerator. It was in plain view. Had no visual red blood stain. And yet the government wants you to think about this knife. So think about it. Don't ignore it. Do not refuse to consider it. Of course you will. But think about it. In a cabinet above a refrigerator. And they first test it with some screening test. It doesn't prove that it has even blood on it. And they take it, and they should. And then, what happens is everybody loses interest of the knife. Everybody, the Mass State Police, the crime lab. There's no further testing of this knife. And ask yourself, if that knife is to be considered a weapon used, then why is it in that cabinet? You have heard evidence of bags and bags being thrown in dumpsters over a period of days. The government wants you to think that Mr. Walshe killed his wife and perhaps used this knife. Then why was it sitting in a cabinet days later in open view for the police?
With the hydrogen peroxide.
What logic is that? And there is no proof that it had one piece of biological evidence on it tied to any killing or any harm. And they simply lost interest in it. You can take it down now. Digital data. Talked about that briefly, but there is nothing in that data. All of that data. And we're talking about text messages. We're talking about backbook searches. We're talking about the life that's embodied in computers that this day and age we know apparently keep track of everything we do and to some extent everything we think about. Because that's how the government is using that data. They ask you to look at certain things and indicate and try to argue that, oh, this is what he was thinking. So look at it and judge for yourself.
Fun fact, when you
What's
Google,
in this data
does
that
the
demonstrates
dishwasher take
premeditation
DNA off a knife?
or
The answer
intent
is
to kill
yes.
or intent to
It
harm?
does. Renders it DNA free.
You have heard and seen much physical evidence. You've seen pictures of gray slippers with blood on them. You've seen pictures of all kinds of physical evidence. And if the argument is made by the government, something about a dark gray slipper with blood on it indicates that a murder happened because, listen to the argument, of course you will. But a theory, an opinion, does not make it true. And to suggest something like, the evidence shows that Mr. Walshe went and bought a Tyvek suit, and maybe there's just not enough blood on the Tyvek suit to satisfy the Commonwealth, and so they suggest that some killing happened, and that's why there's so much blood on that slipper and those slippers and all that other evidence. But ask yourself, what do I know about that evidence now from what we heard? Every piece of evidence was put into a bag, but then was put into a compactor eventually, and was pressed together and been found. And you will see all of this evidence of when they pulled it out of dumpsters and unloaded the bags, and they first put it on damp ground without any paper below it, without any tarp below it. And you heard from no less than 3 witnesses. Mr. Gould from the Mass State Police Crime Lab, Mr. Sheehan from the Mass State Police Crime Lab, and Ms. Salim from the DNA unit. They all consistently said cross-contamination or transfer. They used different terms, but they all agreed. So the evidence, the physical aspect of the evidence, the thing you see in the photographs, the thing you see now, if you open up one of the bags and take things out, is not representative, or may not be representative, of how it looked before. And you must consider that. So when the government makes an argument based on the state of the physical evidence as it appears now, ask yourself, maybe that makes sense, but maybe there's another way of thinking about it. And why is that important to your deliberations? Because you are allowed to rely on what's called circumstantial evidence. You're allowed to rely on inferences. And Her Honor will instruct you on that. I will not. But whatever reason and basis you have for making your choice and determining your decision must be reasonable. And if you, as jurors, talking amongst yourselves, find that some of your fellow jurors say, well, I think maybe it means this, and I believe this, and your other jurors, fellow jurors, say, I think this, and I believe this, you'll all consider it. But if you don't agree, then you have to ask yourself, is that inference reasonable? Is that circumstantial evidence built upon inference? Is that reasonable? And can I use that? And should I use that to try to reach a verdict under a standard of reasonable doubt or moral certainty? What is the evidence that something violent happened in this house? I went through every room as best I could with Mr. Sheehan. There was nothing found in the upstairs bedroom.
He's halfway done.
There was nothing found in the sinks and basins, showers of multiple bathrooms. Nothing found, meaning biological evidence that might indicate something violent occurred. There was nothing found in the kitchen other than a knife that they lost interest in. There was nothing found in the living room that had padding around the fireplace to protect the children from falling. There was nothing in that bedroom where Anna Walshe, Brian Walshe, as adults, enjoyed their life together and had spent their life together, perhaps every night, before she moved to D.C. to take that job. And how do we know that?
Why?
We know that because the photographs show there was nothing there. Even what was characterized as red-brown stains on curtains in the bedroom turned out not to be blood at all. We know that because trained examiners from the Mass State Police examined probably every square inch of that house. We know that because we saw photographs and heard testimony about floor that was dug up based on their experience and training. That biological evidence, like blood, can fall between the cracks of flooring and reside on the subfloor. And so they tore the floor up, and you saw those photographs, and you'll have them. And nothing was found. Nothing at all. I asked Mr. Sheehan about blood spatter, and he forthrightly and honestly said, I'm not a blood spatter expert, but he explained it sufficiently to you. Someone wielding a knife or a weapon and causes blood to let out of a body, and you look for blood that has spattered with directionality. Nothing. Nothing in the bedroom, nothing in the living room, nothing in the bathrooms. No evidence that blood drained down the drains. Could I have Exhibit 217, please? That test that I asked Mr. Sheehan about, the Serotek Hem test, that checks for hemoglobin, for blood, that test, he agreed, can detect blood at the sensitivity of 20 nanograms per milliliter. 20 nanograms. A nanogram, as he agreed, 1/1,000,000th of a gram. Think of how minuscule that is. And they used that all over the house. And so the government elicited questions and answers from many of their state police, the 10 or 20. They didn't call everybody. That's up to them. But apparently there was no need to, because 10 people or more, as Mr. Sheehan had described to you, he was estimating. He was trying to be as honest as he could and credible, and he was. 10 people pouring over that house all day on January 8th. 10 more people or more pouring over that house on January 9th with their tools and their experience, and they don't find anything except multiple bloodstains where? In the basement. In the basement. On the concrete floor. Ask yourself, when you heard testimony that Mr. Walshe attempted to clean, and so therefore they couldn't find evidence in the other parts of the house because he cleaned it. Well, ask yourself, wait a minute. Is that logical to suggest that he cleaned the bedroom up so well nobody could find a thing? He cleaned the living room up where the rug may have been, and they couldn't find anything. Well, then you see those searches where he searches specifically for how to clean concrete. So you might infer, and it might be a reasonable inference, that he attempted to clean that concrete floor. And yet, what was found on the concrete floor? Multiple red-brown stains that turned out to be blood, and in some instances, we can all agree, based on the testimony of Ms. Salim, the profile of those blood drops matched the profile of Anna Walshe. So to suggest that Mr. Walshe did everything he could to clean the basement concrete floor with hydrogen peroxide and mops and cleaning fluids, only to have blood found on the floor, defies a reasonable inference that he was able to clean any part of that house sufficiently to avoid detection. And why is that important? Because nothing violent happened in that house. And that's why there is no biological or blood evidence anywhere in that house. The act of trying to hide the body of his wife and the blood evidence that is seen on that carpet That's what happened. There's no blood in the living room. The inference might be that the carpet was taken downstairs. Because you can look at those pictures. You can look at the physical pieces of carpet, and you should. But there is no evidence of any killing that happened. And there's no evidence that anything was done before Mrs. Walshe died. And there's no evidence of premeditation or anything. There is evidence of lying and disposing of the body. You can take that to one statement. So now we look at the evidence, and I'm just going to characterize it. Some of the evidence that the Commonwealth has presented to you, and there is no question that their obligation is to present to you evidence. But I just ask you to think about, in some cases, how that evidence was presented to you. And I'm going to use a phrase that may or may not be entirely accurate, but it's cherry picking. It's looking at thousands of points of data and asking you to think about it, but not telling you why you should think about it. And what am I talking about specifically? And I'll give you some examples. We already talked about the hole in the ceiling, but let's talk about it a minute. They kept talking to you about that hole in the bedroom ceiling as if it was of some significance. And yet you recall the testimony of Mr. Sheehan. I didn't see anything significant about it. It looked like somebody might have fallen through the ceiling. And there's nothing significant about the pieces that Mr. Walshe had stored in the cabinet in that same bedroom. I asked Mr. Sheehan about that. No, I didn't see anything significant about that. Yet you kept being given that evidence. And then as the evidence developed, for some reason, there's Mr. Murphy. And it came out in evidence that Mr. Murphy had in fact contacted Mr. Walshe because there was a promotion going on. It wasn't that Mr. Walshe said, hey, come and fix this hole, this suspicious hole. No, he was contacted. And he didn't respond right away, but then he did. And for some reason, they keep insisting that that hole is of some significance. But they don't tell you why, they just give it to you. They do the same thing with the searches. Remember when Trooper Keefe was sitting right here and he's asked to look through those thousands of, 250 pages of the search history from the iPhone Mini 13, the phone that belonged to Mr. Walshe, and he's asked to look at it and says, do you see searches there to go to the MGM? Yes, I do. Nothing else. No explanation why that is significant, why it's important to try to determine if a man committed premeditated murder. You're just throwing out pieces of evidence. Why? Why were you given... Why was Trooper Keefe asked to tell you about a song, a partial song title? And when you go over that evidence, look through there if you choose to, and I will encourage you to do that. And you see song after song and movie title after movie title. Why is it that the government throws that at you and says, think about this? For what reason? And then they present to you through Trooper Garino something about a porn movie. I'll just take this opportunity right now to apologize to each and every one of you for some of the questions I asked. But it just didn't make sense that you would take that type of evidence and suggest that it has anything to do with determining whether someone committed deliberate, premeditated murder because there's a word in the title of a movie. And that's what I'm talking about, the quality of some of the evidence here, thrown at you as if it means something, that it's significant, and yet here you are being asked to determine if someone, Mr. Walshe, committed premeditated murder with a specific intent to kill the woman he loved. When we talk about premeditated murder, we talk about planning, you have to ask yourself, did I hear evidence of the conduct of a man who premeditated, a man that had thought about a killing, a man that had planned? I mean, think about what you heard. And we're not going to repeat all those things I've already said, but I want you to focus on one other piece of evidence. I asked Detective Schmidt, when you went down to the basement on January 4th, you saw some bags down in the basement. Yes, I did. What did you think was in those bags? I thought they were pieces of rug. My goodness. What does that tell you about the thinking process and the sloppiness and the lack of any planning or careful thought that you would expect out of someone who had planned a murder? And then he lets a police officer walk down in the basement, and the police officer, based on his training and experience, uses, I think he said, his boot, and he felt it, and he said, felt like pieces of rug to me. Rug? That is in evidence. It has blood.
Might have been pieces that didn't have blood on it.
Think
Blood
about
might have
all
been
of that when
disposed
you're
of.
thinking about it. Did this man, Mr. Walshe, did he plan anything? No. Did he intend to kill anybody? No. Did he kill Anna Walshe? No. The evidence does not support a finding of premeditated murder with specific intent to kill based on the evidence, not based on sympathy, based on the evidence. What's some other evidence that is troubling? Mr. Walshe is talking to the police, and he says, I messenger. When asked about, and he was trying to explain it, things will come up on my phone that I thought were for me, but then it turns out they were for Anna. And so the government seizes upon that evidence and suggests that there's evidence that Mr. Walshe had seen text messages between Anna Walshe and William Fastow. And those text messages between Anna Walshe and William Fastow, some text messages are placed into evidence, and I'm sure you'll look at them. And why would the government want you to believe that Mr. Walshe saw those text messages? Because some of the entries in those text messages are very upsetting. They may very well enrage a husband to read about what was going on in those text messages. So you'll look at them. But ask yourself, as you look at them, and perhaps as you think, I could see that might upset, that might put somebody in a rage. Problem is, there is absolutely no evidence that Mr. Walshe ever saw any text message, because he was trying to say, I messenger, and now you know from the testimony of Trooper Keefe, there's no such thing as I messenger. We're talking about Facebook Messenger. But the important thing is, there is no evidence in all of the digital data that you have before you, in all the digital data that they examined, that Mr. Walshe ever saw anything going on between his wife and William Fastow. And when you look at those text messages, and you might have some question about it, and if the government stands up and says, well, he saw those because he told them that he was seeing iMessenger, which doesn't exist, then ask yourself, why is it then that on New Year's Eve, Anna Walshe is taking all these photographs? It's festive. It's a lovely situation. And she says, in the presence of Brian Walshe, as she and Jim Mutwell were taking photographs, hey, why don't we send a photograph to Will Fastow? And was there any evidence that he reacted, Mr. Walsh? No. And when asked by Attorney Porges, well, so what happened next? And Mr. Mutwell really took efforts to remember, and then he said, oh yeah, that happened right before the young boy woke up and came downstairs, and that was around 10:30. So if you just think about that, then the festive and jovial celebration continued for another 2 hours. There is no evidence that he reacted. Mr. Walsh reacted to them sending a photo. Why? Because he knew his wife had a crush on Will Fastow, and it didn't even make him jealous. And how do we know that? Because she told her friend, Alyssa Kirby. And Alyssa Kirby was asked, and she said, you know, Anna told me that he didn't get jealous. He's not the jealous type. In fact, I wish he was more jealous. Please consider that in the context of this notion that the motive for a killing that did not occur, but the Commonwealth's theory of a motive is anger over an affair. There's no evidence of that. Dr. Atkinson told you. Dr. Atkinson described to you the phenomenon of sudden unexpected death. It happens. And just because it's rare, and just because the government will undoubtedly argue that that is nonsense, listen to their argument. But Dr. Atkinson made it clear it happens. It happens in young and old, male and female. It happens unexpectedly. In fact, it happens with people who have never manifested any problem before. It happens in athletes. And how do we know that it's not absurd, even though it might be rare? How do we know it is an important aspect of what happens to people? Because the laws of this state mandate that the office, the chief medical examiner, get information from doctors, police officers, nurses, when there is a sudden death, when someone is otherwise healthy. They're mandated to investigate that. So there is a statute that Dr. Atkinson told you a little bit about on cross-examination. So ask yourself, is it as unlikely? Is it bizarre? Because Anna Walsh worked out. Yes, she had been sick before. She had been with Alyssa Kirby in the days leading up to this, and Alyssa Kirby wound up having the flu. But that's not what really is at issue here. Sudden and unexpected death may occur because someone is ill. All we know is that it happens. And the fact that someone doesn't believe it could happen doesn't mean that it doesn't. Importantly, though, think about the shock of it happening. Think about the effect it would have on anyone. A lay person that has no idea it could happen. You're down celebrating with your wife and your friend, and then the tragedy happens. And you panic because you can't believe it. You don't understand it. And you don't think anybody's going to believe it. Context. I walked Trooper Keith through all of that information. Something that he had not done yet. And so what did you hear? We went methodically. Sometimes, I'm sure for some of you, it was a little painful. It took a little while. But we went through hour by hour, day by day, that basically was the life and the experience that Anna Walsh and her husband, Brian Walsh, were going through in just the days leading up to January 1st of 2023. And what do you see? And you'll have that evidence. You won't have it compiled in the way that I presented it to you, because Trooper Keith never saw fit to assemble it in a way where you could really see what was going on. But what do you see, and what did you learn from the evidence? Two people communicating by phone and by text, talking about sales of property, talking about investments, talking about the future, talking about reinvesting, talking about buying new property in D.C., talking about all of that, and it's all in the text. Joking when Anna Walshe was ill and stayed home and told her husband that in the text. And then they joke about it. I'll get you a plunger. And she responds, it's right there on the text. Joking back and forth in the days leading up to New Year's Eve. I'll tell you what, I'll buy the plunger, you buy me a Porsche, and then you see him shopping for a Porsche for the woman that he loved. How does it go from, I'm going to find you the Porsche you want, that speaks once again to the financial issues that were non-existent? How does it go from that to someone who is purportedly premeditating and intending to kill his wife? And those texts lead right up until she arrives by plane in Cohasset to celebrate. So, context. Once again, divorce? About 11 minutes of talking about divorce and searching about divorce in 7 days of phone calls. And how did that divorce search come up? It came up in the context of protecting the family assets because they just sold the house in Revere that Jim Mutlow told you about. And they're trying to protect it.
He's 48
and
minutes
the thought
into
is
his
to roll it
45
over in a
minute closing.
1053C. And Mr. Mutlow explained that to you. Planning for the future. That is the relationship between Brian Walshe and Anna Walshe in the days leading up to January 1st. So now we have come to just the evidence that, once again, just explains their relationship. Not supposition. Not trying to make up what they said to each other. You have that in their text. You have that. Then we get to New Year's Eve. We get to a festive event. Jovial, laughter, love, described in various terms, various ways. Not for 30 minutes, not for 1 hour, but for 5 or 6 hours. Laughter, talking about the future. Jim Mutlow described it for you. Brian Walshe cooking, standing across from the island, feeding both of them, talking, laughing. You see in the testimony that, yes, there was an affair. He didn't know it. He loved his wife. He treated his wife like the wife he loved, the mother of his children, until the sudden, unexpected event happened. Imagine you are so in love. You support your wife to get a job in D.C. You're going to take care of the kids because, one, you love your children, but you want to take care of them. You want to share property and protect the assets, so everything goes into her name to protect it because he has this federal case. So let's protect our financials for the future. And then you hear the testimony of Alyssa Kirby. Yes, she was upset. There's no doubt Anna Walshe was upset. What exactly she was upset about? Maybe things weren't going really well in the affair she was having. Or maybe she was, in fact, stressed out. Who wouldn't be? They were living apart. She wasn't seeing her children. Now, maybe, it's up to her. Anna Walshe was a wonderful person and a wonderful mother. And that's why he loved her so much. But she had another life, and she went to Dublin, and that's another piece of evidence. They want to suggest to you he knows something about Dublin. Where is the evidence of that? None. And you hear Alyssa Kirby choked up with tears, sobbing on the stand. but nonetheless recalling a conversation she had on 12/29, 3 days before January 1st. What does Anna tell her? Well, I don't know if I love him as much as I used to. Those are her words. I'm paraphrasing, but that was the gist of it. But I want him to take responsibility. Why? Not so she could kick him out, not so she could leave him, so they could reunite as a family. That was what Anna Walshe was talking about. That's what she was thinking, even though she was stressed, even though she was upset. And things like that happen in families, but families make it through. And that's what she was expressing. That's what she was expressing to her best friend, Alyssa.
He's 7 minutes over his time limit, but it's not a hard limit.
Could I exhibit 169?
The judge has said she's not going to cut him off in a case like this.
We are now at the end of the New Year's Eve party, and they sign the champagne bottle. And we were talking about the feelings and the emotions and the state of mind of Anna Walshe and Brian Walshe, and looking towards the future. And this is on January 1st. This is on the day that the tragedy happened. Can you find it? I'm sorry, 169. Oh, I apologize. My fault. I'm sorry. Exhibit 257. And that's the champagne box that was signed. And what are the words? What a year. And yet we are still here and together. Let's make 2023 the best one yet. We are the authors of our lives. Courage, love, perseverance, compassion. Those are the words of Anna Walshe talking to her husband. Look what she says. What a year, and yet we are still here. What does that tell you? Yes, they had been through a lot. She missed her children. What mother wouldn't? But they were working toward the future. And one final thing about the state of mind of Brian Walshe at this period of time. He made reservations for a New Year's Day dinner so he could be alone with his wife. And the evidence of that is in these records. And I'm not going to have it called up. I'll just tell you. Exhibit 79, page 186. Record 682. That's the data. He's researching where to take her out. And you'll see a reference to Nightingale, a restaurant that I asked Trooper Keefe about. A restaurant that's right on the line of Marblehead and Lynn. Exhibit 59. At 12:27, those records indicate that Mr. Walshe credit card used to reserve dinner for $573.76. So him and Anna could spend New Year's Day celebrating. And Exhibit 170.
$500 for dinner?
From Nightshade Restaurant itself, acknowledging the reservation. And those were the plans that he made. And the government will suggest that's some kind of evidence of premeditation. Well, it's not any evidence of anything but love. And I'll just tell you, when you look at that evidence, you'll see that that email exchange was deleted. It's right there in the evidence. And then you heard the federal probation officer saying he wouldn't be allowed to go there. He'd have to get permission. So yes, did Mr. Walshe lie to his probation officer for what reason? So he could take his wife out for a New Year's dinner, and that evidence, and the evidence that you saw in that champagne box, is what their life was right at the moment before the tragedy happened. That is the evidence. I'm sorry I talked for so long.
Going on 56 minutes.
I apologize. Mr. Walshe loved Anna Walshe, the mother of his 3 children. There's no evidence that he deliberately premeditated a murder. There's no evidence that he ever intended to kill Anna Walshe. None whatsoever. Mr. Walshe is not guilty. He's not guilty of murder. Thank you.
Josh, thank you very much for gifting 5 memberships. Shelly Anderson gifted 10 memberships as well. Thank you both for your generosity.
Take a moment to stand up.
Shake a leg. Kelly H gifted a membership as well. Thank you, thank you, thank you. It is raining memberships right now. The closing by the defense, they bet big on a bluff. As I've said before, they have a 2-7 offsuit. And
when you're ready.
It's not a winning hand, but they were dealt a bad hand to begin with. This is all they have. They've bet big on that. Focus on all the places there aren't blood. Pay no attention to the fact that there was.
Closing argument of the Commonwealth.
The Commonwealth needs to hit a home run here. Address any concerns the jurors might have as a result of the defense closing. And spell this out on the timeline. Please give us a microphone. Please give us a microphone.
You may proceed.
Thank you, Your Honor. Anna Walshe is dead. Anna Walshe is dead because he murdered her, and he intended her death. Anna Walshe is not missing. She never walked out of her class at home on January 1st of 2023 between 6 and 7 a.m. to take an Uber to Logan Airport. She wasn't going to D.C. for a work emergency. There was no emergency. She didn't say goodbye to her son. That's just a story that the defendant told people. But since January 1st, Anna Walshe has not been seen by her friends or co-workers or by the people who loved her. Anna didn't take an Uber. She didn't take a Lyft. She hasn't used her phone. Her phone's had no contact with the Verizon network since January 2nd, 2023, when it was in the vicinity of 516 Chief Justice Cushing Highway. She hasn't used her bank accounts, her passports, her credit cards, her email. She didn't vanish. The defendant was the only adult at 516 Chief Justice Cushing Highway after Jim Bootloop left around 1:30 a.m. on New Year's Day. And after he left, Anna was home alone with the defendant and their 3 sons, ages 2, 4, and 6. This defendant caused Anna's death, and the evidence does show you that. The evidence shows you that Anna didn't die of natural causes, but that Anna died a violent death in her Cohasset home on January 1st. You have the photos of those pieces of rug recovered from the dumpster at the defendant's mother's complex. The rug that had been in the living room. You have the photo of Anna in the living room on top of the rug. And the photo shows that there are wood floors in that room. There's blood on that rug. The rug was recovered from the compactor outside of the defendant's mother's apartment and taken to the office of the chief medical examiner for examination. And Dr. Atkinson found a blood clot and a piece of Anna's Gucci necklace embedded in one of the cut-up pieces of rug. So look at the piece of metal stamped Gucci. It didn't break on its own. The rest of the necklace is missing. This is the necklace that Will Fatstow said that Anna often wore. Look at the slippers from the dumpster. The 2 pairs of adult slippers. The dark gray slippers have hair and blood clumped to the bottom. And the DNA testing tells you that the slippers had the DNA of Anna Walshe and the DNA of the defendant. Then there's the bathrobe. And there are 2 bloody white towels. A towel was tested and had Anna's DNA. Why did the defendant throw those items out? Because they had Anna's blood on them. And the evidence shows you this, because the defendant was researching cleaning. How to clean blood from what floors? Does dishwasher clean blood? Is it possible to clean DNA off knife? The defendant still had a cut on his thumb on January 9th, 2023. And on January 1st, before he even went to Lowe's to buy any cutting instruments, an initial stop that he made when he left his house was to go to Walgreens to buy antibiotic ointment and Band-Aids. Then he went to Bin and Liquors, where the manager identified the defendant, and the defendant threw a bag into the dumpster. Store is closed. The parking lot is empty. He's not yet gone to Lowe's. On January 2nd of 2023, the defendant went to Home Goods because he had to buy a new rug for that living room to cover the hardwood floor. He did this days before the forensic scientists got to the house and knew that the rug had been changed. Anna Walshe dying a sudden death from natural causes defies common sense. She was in great shape. The defendant told police that Anna was a sturdy Serbian woman. Listen carefully to his recorded interviews, because those are his words after her death, after he killed her. Mark Salvaggi told you that Anna had the highest health rating from the life insurance company. Anna had to complete an interview, have blood drawn, provide her medical records, and the life insurance company and the underwriters gave her this health rating. Anna was an active person who took care of her health. Ashley Semino, her bar instructor, told you about this exercise class that she took the morning of December 31st of 2022. And Anna was the type of person, she said, who made others want to work harder in their exercise class. Will Fatstow told you that Anna was very active. They did yoga together. Sergeant Amy Waterman described Anna's home gym in D.C. And Dr. Atkinson told you about the different ways a person can die, and that it's extremely rare for a 39-year-old in good health to suddenly die of unknown causes. But without a body, it's not possible for the medical examiner to tell you the exact cause of Anna Walshe's death. No autopsy can be done. The defendant deliberately got rid of Anna Walshe's body. The defendant did not want anyone to find Anna's body and to know how she died. So the defendant bought cutting tools at Lowe's and Home Depot, and he cut up Anna's body, the woman that he claimed to love, and he threw her into dumpsters. He was hiding her body. The defendant intended to kill Anna Walshe. He didn't just want her dead, he needed her dead. This was a marriage in crisis, and it was heading towards a breaking point. It began with the defendant's federal case. And through the defendant's interview and his federal probation officer, you learn that the defendant was on home confinement. He was going to have to pay over $400,000 in restitution, and the case had been pending since 2018. You also learned that the defendant had no assets. He told Jamulu that he only made $50,000 to $60,000 that year, but he had told the police that he had businesses that were not making any money at all yet. Peter Capozzoli told you that the defendant's mother had signed the lease for the Cohasset home, and it was his mother that was paying his rent. Meanwhile, Anna was beginning to thrive. The marriage was beginning to deteriorate. Anna had her dream job. She had risen to become an executive at Tishman Speyer, and she was making close to $300,000 a year. She earned a bonus. And Teresa Marchese said that Anna was a good employee. And the defendant knew this. He bragged of her bonus and salary. She bought a townhouse, and she furnished that townhouse for her family, and she set up bedrooms for each of her 3 boys. But the reality was, her family couldn't join her because the defendant needed the children with him. Being the primary caregiver allowed him to avoid prison. The separation of the defendant and Anna was taking a toll. Anna wanted the children with her, and Anna began a relationship with Will Fastow, which became more serious. The defendant and Anna were growing apart emotionally and physically. Anna struggled not having her children and not being able to be the mother that she wanted to be. This got worse when Anna took the trip to Serbia to take care of her sick mother. Anna and Will Fastow spent the Thanksgiving holiday first in Dublin before Anna went to Serbia. And Anna bought her plane ticket with the credit card that the defendant monitored. And the defendant told police that he monitored their joint Chase Freedom credit card statement. The MacBook history also shows the defendant looking at the Chase account. The defendant knew about Anna's travel because in a recorded interview, he told the police that she had a layover in Frankfurt, and that connection in Frankfurt is on the same credit card statement. And you can see that, it's right in front of you. The defendant was angry about Anna missing Thanksgiving, and he mentioned it repeatedly when he spoke to investigators.
I got angry about Thanksgiving, and then I realized it was just sad that we're not spending a lot of time together. And she was sad about it too, and it was exhausting for both of us. She was away from the boys, I was always dealing with the boys.
Anna returned from Serbia in December, but she only spent 1 day in Cohasset. And she was supposed to come home for Christmas morning, but she missed her early flight, and she couldn't get a flight, and then she had to drive up. The defendant told police there was an argument.
I did have an argument with her for the Thanksgiving and the Christmas Eve, so I wasn't going to make the same mistake 3 times.
So what did the defendant do on Christmas Day when his wife wasn't home? He looked up Will Fastow on his cell phone, the man his wife had just spent the night with. The defendant was losing Anna. Anna was missing her children and wanted to be them. Anna quickly returned to D.C., and on December 27th, the defendant was looking up the best strategies to divorce for a man and the D.C. divorce laws. This was not to protect assets. That wasn't the search. The defendant told the police that everything was in Anna's name. The defendant had nothing without Anna and the kids. And on December 29th, Anna spoke with Jem Mu'u and told him that she was upset. Upset about the travel, upset being separated from the children, upset about the defendant's federal case. It was ongoing. It was getting to be too much. On December 29th, Anna went out with Alyssa Curry, and she broke down. This strong Serbian woman who was supposed to be having a fun night out with a girlfriend, going to dance karaoke, instead broke down. Anna told Alyssa that she had told the defendant that he needed to take responsibility for the federal case, go to prison. She wanted the children with her in D.C., and she and the defendant had not been intimate in close to a year. In Anna's mind, the marriage was broken. Anna even questioned if she could just take the children because she had already established a separate household. She said that she was falling out of love with the defendant. And at home in Cohasset, what was the defendant doing? He was looking up the Mazda building and the FBI raid on the Crossing building. Looking up something that had happened in the spring of 2022 when Anna first started working for Tishman's Fire. Interestingly, this was when the defendant brought up something he brought up in his interviews when he lied about Anna having to leave early for a work emergency. This thing, the work emergency. The defendant was going to lose Anna, and when he lost Anna, he would probably lose his freedom. Anna would have a house in D.C. and a nice job, and he would likely go to jail. So the defendant pretended. He lulled Anna into thinking that everything was okay. He joked with her about a Porsche. He didn't want her to realize that he was aware of the relationship with Will or her ability to leave him. He wasn't going to let Anna know that she wasn't safe. On December 31st of 2022, the defendant claimed that he could not find his phone. Why is that important? The mislaid phone allowed the defendant to be unavailable for 2 days. The mislaid phone allowed him to carry out his plan uninterrupted. And the mislaid phone allowed him to show the police when he eventually reports Anna as a missing person and not have the police question why he didn't contact Anna earlier. The evidence shows that the defendant was methodical. Just look at how he shopped at Lowe's with a list. He planned it with precision. So Jem Lulu came over for dinner on New Year's Eve, and the defendant told Jem that his phone was lost and it was free. Anna was texting throughout the night, including with Will Fastow. This is now the third holiday where Anna was concentrating on the other man in her life. When Jem left, Anna was alone. She was with the defendant, the man she was cheating on, the man she was telling to take responsibility for his actions, and the man who had her killed her. The defendant murdered Anna that morning in their Cohasset home. And this is what the internet history shows. His internet history, written words. He was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Anna was dead. The defendant killed her, and he began researching how to get her money, how to inherit, how to get away with the crime. And he might have gotten away with it, but he didn't know that his MacBook was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives. But because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Anna leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day, after the defendant told Anna that they were going to have a special party. This is ironic because the defendant was very clear with police on January 7th that he and Anna had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing. The forensics show that the defendant's phone was unlocked 4 times and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And in the January 4th recorded interview, you hear the oldest child needed help with his iPad password, which was 121212. The children didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text reminder. Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant had access to his phone. Context. The defendant also had access to 2 other phones when his phone was supposedly lost. He had Anna's phone and he had the iPhone SE. And in the recorded interviews, the defendant told police that on New Year's Eve, Anna had an argument with a friend, and as a result, Anna put her phone upstairs in his bedroom.
You said she went and put her phone upstairs after that?
After that, she, let's say it's 10 or 15, then she, I remember her putting her phone upstairs because then she came back down without it.
Was, Thomas came down at one point and hung out with you?
Yes. Yeah, exactly.
Was this before, during, or after Thomas was participating as well?
Oh, yeah, Thomas went to bed at, he went to bed, and then he came over at like 9 or 10 or something. I think Anna took a bunch of photos. Jem and I don't have any because she didn't send them to us yet. But I think she sent one to Will Fasto. So that was when, that's when the photo was taken about. So it was maybe 10 o'clock or something like that.
You know where upstairs she put her phone at that point?
Yeah, on her bedstand.
That's not what Jem said. Jem said that Anna was using her phone all night. Melissa Kirby texted with Anna. The defendant was telling investigators a story about Anna's phone. How else do we know that the defendant intended to kill Anna and had a plan for doing so? Look at his internet history. Look at what he did. The defendant set up an area in his basement where he surrounded it with plastic sheeting, wore a tie-back suit, and dismembered his wife, the love of his life. Hacksaw, the best tool for dismembering a body. Then, the defendant got rid of Anna's body. He got rid of her belongings. He got rid of her clothes and bag that he told police that she had, but she supposedly left on January 1st. He threw her in the garbage bags, tossed those garbage bags in different dumpsters, disposing of a body in the trash. Chatham West apartment rental, the Claremont apartment rental. And police confirmed this with the location data from the SE phone and the iPhone 13 mini. The evidence shows that the defendant did this to hide the fact that he murdered Anna. He could not let Anna's body be found because Anna didn't die of natural causes. The defendant murdered Anna, and then he had to hide the evidence of his crime. Look at his mindset, look at his internet history. Want to get away with murder? Use a special detergent. Can you be charged with murder without a body? Best way to dispose of body parts after murder. When you deliberate, look through the binder of the MacBook internet history. There are no searches of natural causes of death, sudden death, heart attack, aneurysm, stroke, or how to help your children when someone dies unexpectedly or goes missing. The defendant was not sad. Look at his demeanor in the surveillance videos. He's cool and calculating. He's calm. He had a plan. On January 1st, he went to the Lowe's store an hour away, even though there were hardware stores approximately a mile from his house. And when he was in Lowe's on January 1st, he wore a mask and he wore gloves and he had a list of what he was shopping for. He was calm as he helped bag the purchases. A hacksaw, buckets. He used cash. Does this show confusion, panic, or fear? But he doesn't stop there. He went to CVS to buy hydrogen peroxide. And then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and candles. And then he went to Home Depot, where he had bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer. And he lied, and he said that he was picking up his children. He was able to calmly Speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it into dumpsters, because he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with a store exchange card. He was calm. But Alyssa Kirby texted him on January 4th asking about Anna, and so he called Tishman's Fire a few minutes later and started to pretend to look for her. He called Will Fastow, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can.
He took his child with him.
Not competent. The police were coming to the house and to talk about Anna. And the defendant had the house ready. The police think his wife is in D.C. He had his phone ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to Anna. I still love you. Ha ha. His joke. The defendant prevented anyone from ever finding Anna's body, and there was no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body, and all that remains of Anna are a few hairs, some blood, and a few things that belong to her. A part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and a few other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing of Anna's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walshe.
Less than half an hour for prosecution to present their case. Defense went over an hour on their side.
I will see counsel at the side of the bench.
Judge making sure all the I's are dotted and the T's are crossed as we go through. I know the timing is a little awkward, but thank you for the massive gifted membership train that ran through half the closing statements for the prosecution. Absolutely amazing. Over 125 gifted memberships, just one after another. You guys are amazing. Thank you so much for that. Welcome if you're new here and you got a membership. It's amazing. This is an amazing community. You're a part of us now. Please stick around. We are going to do a poll here in a little bit. Thank you, Coach Hannah. 25 months here in OG. What a wonderful community to be a part of. Thank you. Welcome, Coach Hannah. Congratulations on 25 months. Would not be the same without you here. The chat was extreme.
You're my guidepost. Do you need a break to the bathroom? Okay. All for one for all. Give you a break to the bathroom. Let us know when you're ready to come back out. I'll be at your disposal.
We do get a little break.
All right, please. Jurors, follow me.
It is 11:26. It's about 26 minutes after the time that they normally take a half-hour break. So we might get that break now. I think the prosecution did a good job. They linked things together. They stressed the important things about the timeline that were crucial, and they didn't try to fit every piece of evidence into their closing. They didn't try to cram the entire case into 30 minutes. Just, like a high school debate team, the person who says the most words win. They came in short, they were succinct, and they were direct. And I think it resonated with the jury, and she didn't yell at them. That also.
I will give you a quick break
great.
as well, but something's been on my mind
that
I want to discuss now that the closing arguments are over.
Laura Lee, thank you very
That
much.
is, I had asked in connection, this relates to the sentencing, at least for the other two counts, and asked the Commonwealth to provide victim impact statements for any immediate family members of Anna Walshe that wish to provide information, and I haven't received that yet. And there might be a good reason for that. I had told you that I was putting off the sentencing until we had a verdict on the charge of murder. But now that it's a Friday, and I don't want this to linger over into the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded. And I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children and the social
I think there's a
work.
valid privacy interest of the children, and I'm highly likely to impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as a result of the victim impact statement.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I
That
step
means
off the bench briefly?
The kids do have something to say.
Thank you.
It's very difficult because it's said through a social worker. It's that they are still young. There are protections between that need to be recognized, and this has to be done properly. Being impounded means we will not hear it or see it. It will never see the light of day. The judge will read it, and the prosecution and defense will see it. Other than that, it will remain sealed indefinitely. But it will mean that the judge gets to consider, should we get to a verdict and sentencing, the judge will get to consider that in the sentence, and the impact that this crime, if found guilty, had on the children. So, who has the children? The way they say it, it's got to be the state. The state still has custody. You've got a social worker working on. They've got to still be in custody, and they are in protective custody in that they're keeping it secret. The state is not allowed to divulge that for their own protection. Has anyone changed their mind from murder 1 to murder 2? Me, I did this morning, actually overnight after listening to the judge. This is going to be. I'm setting up a poll right now. How long will the jury deliberate? Less than 2 hours, 2 to 4 hours. First thing Monday morning, because we've only got about 4 hours left of court today, assuming they don't stay late on a Friday night. And I'm going to put the last option as hung jury. Hung jury, no decision, no verdict. Okay, there we go. We are starting the poll right now. Please vote carefully. Read every poll. It does you no good to be the first person to respond if you vote the wrong thing. Okay? So we are starting the poll right now. What changed it for me? Pantuflay, the thing that changed it for me was actually the judge. And that's a weird thing to say because the judge is not, it's not evidence, but she just reminded me of things that we had heard and put them in the order, the sequence of events that made sense. And the pieces fell together for me that way once I was able to hear the order that everything happened in. We had Brian Walshe going to the store to buy booties and a Tyvek suit. We've got the receipts. We know he got it. It is reasonable to believe that he bought them to use, to protect himself from getting contaminated with blood from the crime scene. We have the evidence that's not a logical, a jump to get there. We have the evidence that that's what happened. If he bought these tools and bought the protective materials so that he can dismember his wife who's died suddenly, how then do we get his and hers bloody slippers? Unless there was a bloody crime scene first. You don't get there. You can't get there. The bloody slippers had to have happened first, and it's both pairs. They were both wearing them. Yeah, they got ready for bed. She never made it that far. She made it to the rug in the family room and then rolled in the rug and dragged down the stairs where we have a broken step, where we have the blood. I know the step broke when the investigators were walking on it, but I haven't had a broken step before. It's cracked first and then it breaks later. I've had a broken step in my basement as well. It all makes sense. It all fits together perfectly. The evidence points to this. Let's see. He did that prior. Yes, before he goes to the dumpster and throws something away, before he goes to Lowe's to buy anything. He searches for how to clean up things. Before he goes to Lowe's to buy any dismemberment tools, he's disposing of things in a dumpster. I think it's quite clear. Pantuflay, hope prosecution made that link without judge's help. I think the jury wasn't present, so it doesn't matter what the judge told us outside of the jury's presence. I think if anything, if somebody's saying, that's improper for the judge to say that, if anything, I think it was a benefit to the defense to hear that, to hear an argument, to hear something laid out that clearly, because defense was then able to counter it. Normally, the defense goes first, right? In Massachusetts, they go first. Defense goes first, and then the state comes after. So you don't know what the state's going to say. It gave them a peek behind the mirror, so to speak, and know what was coming up. So, I think it was beneficial for the defense. No complaints from them on that front. But the jurors didn't hear the judge's argument. We didn't, but we heard basically the same thing from the defense. And this is what makes it so good. Mr. Tipton got up and spelled out the judge's argument exactly. They may say this. At that point, I'm like, whose side are you on? Because you're presenting a very rational, reasonable explanation that makes sense, that evidence all points to support that. And you're presenting that to the jury, and it's like, just no, that's not evidence. I'm like, yeah, the evidence is there. The evidence is there. For me, it worked. Let's see. That was weird. There were a couple times where I wondered whose side Mr. Tipton was on, but he has to just argue with what he's got. He has to use the evidence that's submitted to make his argument. Did you hear? He never said how Anna died. He calls it the tragic event, the sudden, unexplained tragedy when the event occurred. He left it so broad that the event could include a fight. He literally, he did not mention natural causes at all. He has nothing to insert there because there are facts not in evidence. He left it so broad. all the gifts and likes today. Amazing gifting. Over 125 membership gifts during closings, which was just an amazing string. Just 5 after 5 and 1 and 5 and 1 and 5, 5, 5 and 1 and 5. It was absolutely incredible. You guys are amazing. It makes it hard to read chat when it gets, my eyes get really sweaty. We're on break, not verdict watch. It's true. We have not started the timer yet. The jury still has to get additional instruction from the judge, including the instruction on how to clear out, to fill out the verdict form and what to do if they have any questions. Picking a foreman, if they're going to do that themselves or the judge going to sign that. We're going to find that out in just a moment. At the end, he said it was unintentional. That's basically what he said. He never intended for this to happen. It's like you're basically waving the white flag on murder too, Mr. Tipton. Let's see. Grit Grinder, thank you very much. Cal's Bells, thank you for your generosity. One of the amazing gifters. Thank you, Grit Grinder, as well. Olga gifted another 5 memberships. We're not done, apparently. Congratulations to the recipients. Tammy Dunlap says, I'm still gray. And Tammy's been making pancakes for all the birthday people all this time. Tammy Dunlap's house, one of the places you can get free pancakes every morning. I think I've got to give Mr. Tipton, somebody set it up here that I want to catch. Right here, Carol. All the attorneys were competent and professional. I appreciate that. This was a phenomenal case that way. The professionalism across the board from all the judge, the prosecutors, and the defense was amazing. It's refreshing to see. Although we like some spicy exchanges back and forth. Cal's Bells, you're still going. Kim R as well. Oh my goodness. It's refreshing to have a case where we can focus just on the facts of the case, on the guilt and innocence factors, just as the jury does, and not have this drama exchange going back and forth where I think they're going to fight it out in the parking lot after lunch. It was quite refreshing. And I think Massachusetts needed that because they got a little bit of a black eye from the last time we were up here. Ellie Veldman gifted 5 memberships. Thank you very much. No death penalty in Massachusetts. No life without parole is the maximum he could face on this one. Bree gifted a membership as well. Goodness gracious, 'tis the season, says Stacy Mathis. The judge, yesterday, if you missed it, when the judge was talking to the jurors and basically thanking them for their work, well, I think she did that today. She was talking to the lawyers yesterday, and she was thanking them. And she basically said, I go from county to county. I cover multiple counties, and I work with a lot of people. And what I see here in this courtroom, the professionalism that you guys convey yourselves with, and with how you act and with each other and with me and the court and everything else, the court officers, it's incredible. But it's what I see every day. She's like, but this is the norm for Massachusetts, right? This is how we are up here. And I think that was for us more than it was for the lawyers. She's trying to definitely paint a better picture for the legal system than the one that was left in the previous trial. Sherry Smith, thank you very much for your generous donation of a gifted membership. Evangeline Light gifted another 5 memberships. Oh my goodness. Wow. No whammies, says Candace. Greeners are like, how did Massachusetts get a bad rap? I don't know. It just sort of happened. So much generosity. I love the words the judge uses. I do as well. I like that she's professional. She's courteous. She's thoughtful. Her legal mind is sharp. Being able to look at the effects. This is something that's important. Lawmakers in general don't have this, right? Lawmakers are typically, and I'm sorry if you're a legislator, they're typically reactionary people where they see a problem, let's make a law to fix it. The judge has to look at it and say, if I do that, then what? What's the impact down the road? What will this cause? And maybe it's because there's always the appeal possibility.
Everyone's not. Thank you.
The judge is amazing. Looks like we're just waiting for the jury. Sherry Smith gifted another membership. Thank you, Sherry. Courtney, our Leo, just gifted a membership as well. Congratulations to the recipients. It's raining memberships. Hallelujah.
All rise to the court, please. Jurors entering.
That was a nice, clear sound.
Court is back in session. You may be seated.
Welcome back, jurors. Jurors, I'm going to go through the remainder of the instructions, the final stage of this case before you will get the case to deliberate. The intent of the second part of the instructions is to give you some assistance in determining how you go about deciding whether the Commonwealth has proven each element of the indictment is true beyond a reasonable doubt. For the charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of the charge. You may not find the defendant guilty on the charge just because you think the defendant did something else that was wrong or improper. Your decision as to the charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip. When all 12 jurors agree on the verdict, the foreperson should check off that verdict and then sign and date the verdict slip, in ink. In a little while, I'll go over that verdict slip a little bit more. For the charge, if you all agree that the Commonwealth has proved every element of murder beyond a reasonable doubt, then you should find that Mr. Walshe is guilty. On the other hand, if you all agree that the Commonwealth did not prove one or more of the elements of murder beyond a reasonable doubt, then your verdict must be not guilty. Let me talk about your role. Jurors, you have the most important role in this trial because you will decide who and what to believe and whether the Commonwealth has proved Mr. Walshe's guilt beyond a reasonable doubt. You must be completely fair and impartial and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. All parties who come before the court stand as equals before the bar of justice. That a case is brought in the name of the Commonwealth does not entitle the prosecutor to any special consideration. Your verdict must be based on the law as I have given it to you, and on the evidence and the facts as you find, and nothing else. By contrast, my job as the judge is to impose sentence if the defendant is found guilty. Therefore, you are not to consider the sentencing consequences of your verdict at all. That's not your responsibility. So please put any issues about sentencing out of your mind. Let me next talk about evaluating the evidence. You must decide this case based only on the evidence that was presented at trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence. And you may not base your verdict on guesswork, speculation, or suspicion. Let me talk to the important topic of the defendant not testifying. As you know, Mr. Walsh did not testify in this case. You may not hold that against him. Mr. Walsh has an absolute right not to testify because, as I've explained, he is presumed to be innocent and does not need to do anything to convince you that he is innocent. It does not matter why Mr. Walsh did not testify. It's not relevant to what you must decide, which is whether the Commonwealth has proved, based on the evidence presented at trial, that Mr. Walsh is guilty beyond a reasonable doubt. The fact that Mr. Walsh did not testify is not evidence. You may not consider it or even discuss it in deciding this case. Let me next talk about witness credibility. During this trial, you've heard from a variety of witnesses. With reference to any and all witnesses who have testified before you, you have wide latitude. As a jury, you can believe every single word that a witness says on the witness stand, or you can disbelieve every single word that a witness says on the witness stand. You may decide to accept parts of a witness's testimony and to reject other parts of his or her testimony. That's for you and you alone to decide. If there are any conflicts in the testimony, it is your function to resolve that conflict and to determine where the truth lies. In evaluating the credibility of witnesses, you may use various tools. You may consider the ability, the opportunity, and the reliability of the witness to see or hear something in the past, and then remember and later testify about it before you in this courtroom. You may consider the conduct of the witness, his or her manner of testifying before you, any inconsistency you may have found in the witness's testimony, any interest the witness may have in the outcome of the proceedings, any bias or prejudice or hostility the witness may have demonstrated while testifying before you, the level of accuracy of the witness's testifying before you, and the reliability of the testimony as it developed before you. These are some of the tools that you have at your disposal to resolve disputed issues of fact in this case. There's one more point about witnesses that I'd like to specifically address, and that's expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field, generally in cases that are tried in our courts, both civil and criminal. Witnesses may testify to facts that are within their own personal knowledge. That is, things they've personally seen or heard or felt. However, in a variety of cases, this one included, issues arise that are beyond the experience of laypersons, and in those types of cases, we allow a person with specialized training or experience, we call them expert witnesses, to testify not only to the facts, but to their opinions, the reasons for his or her opinions, on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in a field, doesn't put that witness on any higher level than any other witness. And you are to treat the expert witnesses just like you would treat any other witness. In other words, as with the other witnesses, it's completely up to you to decide whether you accept the testimony of the expert witnesses, including the opinions that those witnesses gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such witness in whole or in part if you determine that the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind, jurors, that you alone decide the facts. If you conclude that an expert witness's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember, jurors, that expert witnesses don't decide cases, juries do. In the last analysis, an expert witness is just like any other witness, in a sense that you alone make the judgment about how much credibility and weight give the expert's testimony and what conclusions you draw from that testimony. Let me next talk about graphic photographs. The Commonwealth has introduced certain photographs showing items taken from various trash bags retrieved from 300 Forest Street, Peabody, during the investigation of this case. You will have those photographs with you during your deliberations, as all the evidence will be with you during the deliberations. Some of those photos, as you've seen, are not pleasant. Indeed, some may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by those photographs. Related to this, sometimes evidence is presented that produces in jurors an emotional response. For example, it is natural and understandable to feel sympathy and empathy when you hear or see testimony that suggests what might have occurred on a Walshe's body after her death. But as jurors who have taken an oath to follow the law, I instruct you that you must separate any emotional response or reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony and video evidence. You must find the facts in this case based only on the evidence. You can't find facts or base your decision, again, on sympathy, anger, passion, or prejudice, or pity for or against either side in this case. Rather, again, jurors, your verdict must be based solely on the evidence in this case and my instructions on the law. So what is evidence? I told you earlier that repeatedly that you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of the witnesses, as you recall it, the things that were marked as exhibits, and the stipulations, or I told you those agreements, of the parties, which I read into evidence. You will have the exhibits with you in the jury room. Things that were marked for identification aren't exhibits, so don't be looking for those, because they're not exhibits, and you won't be able to consider them. Other things that are not evidence and you may not consider when deciding this case are as follows. The fact that the defendant had been indicted and charged with a crime, not evidence. Questions that the lawyer asked of a witness are not evidence. Only the answers given are evidence. For example, if a lawyer asked, wasn't it raining outside? And the witness answered no, or said, well, it was cloudy. The question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection and therefore the witness didn't answer it, then neither the question nor the fact that the witness did not answer is evidence. If I struck or told you to disregard any part or all of an answer by a witness, then the part of the testimony that I struck, not evidence, you may not consider it. Anything that you may have seen or heard when the court wasn't in session isn't evidence. The opening statements and closing arguments of the lawyers are not evidence. And if your memory of the testimony differs from what the attorneys said in their closing arguments, you should rely on your memory. Any notes that you've taken, they're not evidence, but you may use your notes to refresh your memory of the evidence. As you know, evidence can come in many forms. It can be testimony about what someone saw or heard or smelled or felt. It can be someone's opinion, and it can be an exhibit. Whether the evidence is direct or circumstantial, sometimes we call that indirect, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence in the case. Some evidence proves a fact directly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that's direct evidence it was raining. Some evidence proves a fact indirectly, circumstantially. For example, Let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off of an umbrella. That's indirect evidence that, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some known information, we apply our intelligence and common sense, then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. Also, you may draw an inference even if it is not necessary or inescapable, so long as it's reasonable and warranted by the evidence. You have to decide, jurors, which inferences are reasonable, and decide which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. The Commonwealth may be able to prove a criminal charge with direct evidence, indirect or circumstantial evidence, or a combination of both. Let me next talk about credibility. An important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or deliberately lying. If you conclude that a witness lied to you about something, then of course you should not believe that part of the testimony. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something but actually be mistaken. For example, the witness might not have paid close attention or might have misunderstood what was happening. Or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful, but that some part of that person's testimony was inaccurate, then you should not consider the inaccurate portion. How do you decide whether you believe a particular statement by a particular witness? Well, ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Did the witness's memory seem accurate? Was the witness's testimony consistent with other evidence, or instead contradicted by other evidence? How did the witness behave and answer questions while on the witness stand? Did the witness have any motive for testifying in a certain way, or have any other bias that may have influenced the witness's testimony? You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way as you would evaluate anyone else's testimony. You must not automatically believe or automatically disbelieve a witness just because a person is a police officer. Moving next to the importance or significance of evidence. It's up to you, jurors, to decide how important each part of the evidence is, whether it's testimony by a witness or an exhibit, whether evidence is direct or indirect. You should give each piece of evidence whatever significance you think it deserves. You're not required to believe something simply because it appears in an exhibit. It's up to you to decide how important any exhibit is. You do not have to treat testimony by a witness as more or less significant than the exhibits. You may find that a witness's testimony is very important, or that an exhibit is more important. That is up to you. Next, I want to talk about the alleged victim's state of mind. You heard evidence of statements on a Walshe allegedly made to William Fausto, Jem Bootlew, and Alyssa Kirby. Those statements are admissible for the limited purpose of establishing Anna Walsh's state of mind. as may be relevant to the defendant's motive or intent to kill. Those statements cannot be considered as proof of the criminal acts charged or as proof that the defendant had a bad character or a propensity to commit any criminal offense. Let me next talk about motive. First, motive is not an element of the offense of murder, and the Commonwealth is not required to prove or show motive. Evidence of motive can be relevant to the issue of intent. Second, an absence of evidence of motive may tend to raise a reasonable doubt. Third, even a total lack of evidence of motive would not necessarily raise a reasonable doubt as to the guilt of a defendant, so long as there is other evidence produced that is sufficient to prove the guilt beyond a reasonable doubt. Let me now move to the area of something called consciousness of guilt. I spoke earlier about inferences and the drawing of inferences from indirect or circumstantial evidence. At this point, I want to talk about a particular type of inference based on a legal doctrine called consciousness of guilt. In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest and that he may have taken steps to conceal Anna Walsh's body after her death. I want to stress to you that I'm not suggesting that he did so, or that you should find that he did so, but only pointing out that there was evidence to that effect. It's up to you to decide what evidence to accept or reject, and what facts to find from the evidence. I point to that evidence to illustrate the legal point involved. If you find from the evidence that the Commonwealth has proved that the defendant provided false information to the police and or took steps to conceal the body of Anna Walsh after her death, then you are permitted to consider whether such actions indicate feelings of guilt by the defendant, and whether in turn such feelings of guilt might tend to show actual guilt on the charge.
It's the consciousness of guilt stuff.
You are not required to draw such inferences, and you should exercise great caution, and do not do so unless they appear to be reasonable in light of all the circumstances in this case. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, for such feelings are sometimes found in innocent people. If you decide that such inferences are reasonable, it's up to you to say how much importance to give them. But remember that such evidence is never enough by itself to convict a person of a crime. You may not find a defendant guilty based upon such evidence alone, but you may consider it along with all of the other evidence in this case. Next, I want to speak to impeachment by the defendant's prior or subsequent bad acts. The only charge the defendant is now facing is the charge of murder. You have heard mention of other acts allegedly done by the defendant, namely, that he was charged in 2018 and sentenced in 2024 in a federal case involving art fraud, and or that he lied to the police, and or that he disposed of the body of Anna Walsh, and or that he lied to his federal probation officer. You may not take the defendant's prior or subsequent acts as a substitute for proof that he committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. You may consider this evidence solely on the limited purpose of the motive state of mind, intent, plan, or absence of mistake or accident on the part of the defendant. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed these other bad acts, that he must have also committed murder. It would be extremely unfair to consider this evidence for those purposes. Moving next to your notes. Many of you have taken notes during this trial. Your notes may help you remember the evidence, especially the testimony, but of course they're not an actual transcript or official recording of what was said. So use your notes only to help you remember what you saw and heard in the trial. Whether you took notes or you did not, you must rely on your own memory of what the witnesses told you. After the trial is over and you've returned your unanimous verdict, the court officer will collect your notes and I will order that they be destroyed. During the trial, the lawyers occasionally, as was appropriate, objected to questions posed by the witnesses. They may have asked to strike something or, in essence, erase something you saw or heard. When a lawyer believes that something would violate those rules of evidence we've talked about from the beginning, that's the only way they have to let me know. And so don't hold it any against the lawyers that they made such objections. It's part of their job. I want to next turn to fairness. Each of you has taken an oath and promised to be fair, and I'm sure you want to be fair, but that's not always easy. Part of being fair is being willing to examine your decision-making process to be sure that you base your decisions as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions, and they exist even if we're not aware of them. We all have them simply because we're human beings. They affect our actions and decisions without us even realizing it. As a judge, I have the same problem as everyone else. So let me share a few strategies that I found to be useful. These strategies will help you make sure that you decide this case based, again, only on a careful examination of the evidence and on the legal rules that I'm teaching to you. First, slow down. Do not rush to a decision. Take time to consider all of the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we might not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were from different social or economic groups, or different ages, genders, gender identities, or sexual orientations, or came from a different racial or ethnic background? Fourth, listen to each other. Other jurors may have different points of view. If so, they may help you make sure you're focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions. So don't hesitate to share your views. You should participate actively, particularly if you think other jurors are overlooking or undervaluing evidence that you think is important. When you explain your thoughts to your fellow jurors, you help everyone focus on the evidence. If you do these things, then you'll play your part in reaching a decision that's as fair as is humanly possible, and that's your obligation as jurors. Now I'm going to move to giving you some instructions about how to conduct your deliberations. Privacy. The first point you need to know is that you must keep your deliberations secret. You should not tell anyone outside of the courtroom, not even me, anything about your deliberations. For example, please do not tell me or anyone else the results of any votes that you may have taken before you all agree on a unanimous verdict. You must not tell anyone about how your discussions are going or what other jurors are saying. If you need to communicate with me before you reach a unanimous verdict, you should send me a written note and a form that you all agree on. The court officers have it. It must be signed by your foreperson, and I will discuss your note with the lawyers, and then I will either send you a response in writing, more likely, or bring you into the courtroom, less likely, and respond to you in person. If you do send me a note, do not mention any votes that you have taken or anything else about your deliberations. Do not talk about this case unless all of you are present and no one else is in the room. If one of you needs to leave, even for a moment, the rest of you should stop deliberating until that juror returns. That includes the bathroom breaks, because I know that's right inside your spot. If we break for the day without you reaching a unanimous verdict, you must not communicate with the other jurors about this case until the next day, only after we gather in the courtroom, and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone else about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with electronic devices, a cell phone or a tablet. This also will apply to the alternate jurors. We talk about those alternate jurors. The law permits only 12 jurors to participate in deciding a criminal case. There are 16 of you here. So in a few moments, our clerk is going to randomly select 4 of you to be what we call alternate jurors. The other 12 of you will work together to decide this case. We chose 16 of you originally in the case, just in case one or more of you got sick or needed or had some other unexpected emergency. If you are chosen as an alternate, your continuing service is still very important, and you must comply with all the rules that I placed on you. The alternate jurors will stay in another room, and you can't have your own private deliberation. You can't discuss the case
This is the worst.
with each other or with anyone else for obvious reasons.
The alternates get
If we
stuck
lose
in
a deliberating
timeout.
juror in the group of 12 because of some personal emergency or sickness, then I will send one of the alternates into the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. One of you is going to serve as the foreperson of this jury, and we will discuss who that foreperson is going to be in a moment. Foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinion of all of the other jurors. Once you agree on a verdict, the foreperson will fill out the verdict slip and will report your verdict in court.
All right, they pick the foreperson and then pick the jurors.
Next, talk about making decisions as a group. When you work together as a jury, you will be making decisions as a group. This kind of decision-making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You've all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, well and truly, try the issues between the Commonwealth and the defendant according to the evidence and the law. So, you are all equally qualified to reach a verdict. I have a few more suggestions that might help you work better together. First, you should discuss and analyze the evidence before you take any votes about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as jurors, And as the other jurors talk about the evidence that they found important, listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your own thinking. Fourth, don't be shy. As in any group, some of you may feel more comfortable than others sharing your thoughts, but you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one that remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it's the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, jurors, each of you must decide this case for yourselves. One last pause to consult with the attorneys.
Okay, so the judge is checking in with the attorneys to make sure there's no objection thus far in the instructions she's given. If there's anything that needs to be corrected, she can do it now before they begin deliberations. I haven't heard anything that's objectionable. It sounds like she followed all the advice that she was given, and the counsel as they sorted this out in yesterday in hammering out the jury charge, and we're almost there. We're almost there. We will have a verdict counter on the screen. I guess you can call it a verdict watch. Timer on the screen, which I'll adjust here a little bit so it's not going to make everyone's OCD just go nuts. But and as the thousandths of the second drop off, we'll trim those off. So the poll is still up. How long are they going to deliberate? So get your vote in now so it's valid. Judge wants a long deliberation. She said, don't rush this. Take your time.
I talked to you about a four-person, and I talked to you about what we call reducing the jury. That is, reducing you down from 16 to 12. I'm appointing juror number 138 in seat number 6 as the foreperson of this jury.
Judge picks the foreman.
Our clerk is now going to randomly select 4 of you from among all of the jurors except the foreperson to serve as alternate jurors. So what's physically happening is juror number in seat number 6, juror number 138.
Like this.
Number is coming out of
the bingo machine.
Thank you, Madam Clerk.
What I don't like about this.
1 through 16, with the exception of number 6.
Oh, man. Somebody grease that thing. It's terribly loud.
Our first alternate is a juror in seat number 12.
Grab me. Then no hook him to swallow, man.
Seat number 12, you're an alternate.
Next alternate is a juror in seat number 5.
Seat number 5. Can I get a B5? B5. Bingo.
Juror in seat 15. And our last alternate, Your Honor, is juror in seat number 11.
11, 12, 5, and 15 are the alternates. The judge picking the foreperson, I don't like. The judge has...
One last substantive thing that I want to go over with you jurors before I really get into finally the concluding remarks. And that is, I said to you earlier in this second part of the charge that I would go over the verdict slip. There is a verdict slip, and I know that you can't, unless you have stellar vision, you can't see it from where you are, but you can get the layout of it. I'll read it to you. The verdict slip reads, count 001, on or about January 1st, 2023. And it puts the charge, murder in the first degree with deliberate premeditation. That is the charge. We, the jury, find the defendant, and there are 3 options. Not guilty, guilty as charged, murder in the first degree, guilty of murder in the second degree. And there's a place to sign it and date it. And again, the foreperson in pen, not pencil.
Pretty straightforward. I like that.
This time, Madam Clerk, I'm going to ask you to swear in the court officers.
Do each of you solemnly swear or affirm that you will take charge of this jury, keep them in some secluded places where they can be. Each not speak to them or suffer anyone else to speak to them except by order of the court or ask that they be meeting. So
So now the deliberating jurors, the 12 of you, are going to go instruct with private discussions. Have confidence in what you are about to do. By serving on this jury, you carry out a long and proud tradition of citizens of the Commonwealth of Massachusetts serving on jury trials and deciding criminal cases. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict, dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in the courtroom during this trial. All we expect from you jurors is that you decide this case with integrity and principle. And with that, I'll ask you and let you go back to the deliberation room to begin your work. Thank you very much.
We'll give him just a second.
All right, please.
We'll give him just a second to
follow me.
Step out, and we'll start the timer. I don't like the judge choosing the foreperson because the judge has the same vantage point that the lawyers did, and they read the jurors. You can tell what a juror is thinking, what they agree with, what they don't, unless they're great poker players. And the judge choosing the foreperson puts somebody that she wants, for whatever reason, in charge of the jury. I don't like that. But yes, Massachusetts law, the judge picks the foreperson. I like how it's done in other states better. All right, we're starting the timer now.
I will, as I said to you at the side of the bench, there's some small edits necessary in fact. You may be seated. There's some small edits that I need to make to the instruction.
Judge, can you go back to your mic?
I'll make those now, take the draft off, make sure the numbers are all right for the index that goes down, put down. Anything else that the parties need to bring to my attention before I do that?
We received materials to secure those items, and we're going to work on
Can
that.
I see that? Are they been secured yet, or you're going to secure them?
We're going to secure them. I haven't had the opportunity yet.
All right, let Madam Clerk know when that's done, because I do want to take a look at those before they go in. And of course, our court staff as well, court officers might want to take a look at those to make sure that they're comfortable with what's going on in the jury room.
And we thought we'd cut up pieces of parchment paper for the jurors if they need to examine anything that they can place on their table.
You have a roll, they can do it themselves.
We have a roll. We can give them scissors if you want.
Well,
The judge doesn't want to give him anything sharp.
That's why I put that out there.
We trust our jurors to make a life and death decision about the defendant, but just not to actually have something that can implement life or death.
familiar that I have a 10-minute rule, which means at all times, Madam Clerk should be careful that you should be able to return to the court within 10 minutes, all right? I won't take it further between the hours of 1 and 2 on any day to give an opportunity to tend to your other work.
Thank you, Ron.
Okay, what she just said was very important.
All right.
She said, I need all of you to stay, basically make yourselves available to return to the courtroom within 10 minutes. So stay on a 10-minute timer outside the courtroom, and I won't take a verdict between the hours of 1 and 2 on any day, because that's lunch, and I'm eating. Or she didn't say that part, but that's basically lunchtime. So we have here, it is 12:25. in Massachusetts and here in North Carolina where I am as well. I'm going to fix this timer so it doesn't drive you guys nuts. We'll get rid of, let's see, we'll get rid of that part. But I just like to know exactly what time it is. So let's bring this back out. We have a little bit of a little dot that floats around us because our actual timer looks like this. That's why you see the circle that's going around. Bing, it's a 5-second circle. Oh, it's a 4-second circle. Anyway, so we have a break. It is anticipated that the jury will not make a decision before they get the evidence, right? The evidence has to go back there in case they need to look at anything. It's possible that the jury could be like, "We're done, Judge. Gather the troops. We are ready." But they might. I would say that because she's told everybody that you have 10 minutes to get back to the courtroom, that if at 12:50 we don't have any indication that we're coming back for a verdict right before 1 o'clock, that we won't have a verdict before 2. So that means, I guess, let me end this poll first now that we've got all this additional information about how the judge manages the verdict times. Ending the poll in chat, we have a, let's see, looks like we've got almost 1,200 votes on the poll. So a good size pool here. Give me a second to massage the numbers a little bit into a readable format. The question was, how long will the jury deliberate? And we had a number of options here. It gets the spaces out of here. I have to put spaces back in. I'm not changing the numbers, I promise. One more. There we go. All right. There's our results from the poll. With just shy of 1,200 votes, how long will the jury deliberate? 2 to 4 hours, 64%. Less than 2 hours, 22%. Obviously, that because of the judge's ruling, that's going to be even less likely. First thing Monday morning, 11% hung jury, no verdict, 3%. So most of us are looking for a verdict music this afternoon. And by verdict music, if you haven't been here on the channel before, when a verdict comes in, we do play verdict music. And we play it because a lot of you are at work. And for that, I'm sorry. No, it's great. It's great. Keep up the work. Millions depend on you and your tax dollars. When you're at work, you're busy, you might have this on in the background, and I know you don't want to miss this part of the trial, having watched all the way up to that. And so we do play music that will get your attention. It is a little bit louder than everything else. It probably violates the FCC standard on streaming, which is going to be coming soon because it is louder. But it's to get attention, and it's to sort of rally the troops to see the culmination of this journey to justice take place. And sometimes that justice is not guilty, and sometimes that justice is guilty. So that's why we do it. It's not in any disrespect for the court or anything that has happened in this trial. I hope you don't get offended because of that. Tell me about the FCC thing. I get nerdy magazines about TV broadcast technology because I love that stuff, as you know. And one of the stories that's mentioned is the Federal Communications Commission is expanding the rule. Currently, there's a rule that covers broadcast television that the commercials cannot be louder than the main programming. It all has to be a fixed max volume level. That has not, as of yet, applied to streaming on the internet. They're talking about bringing that onto the internet, and most likely it will be streaming services like Hulu and Netflix and Amazon Prime, things like that have built-in advertising in it, but it might touch YouTube as well. If that's the case, the YouTube might have to take a little more firm control over the volume levels and make sure that the volume levels don't exceed the FCC warnings. It's great for people who want to fall asleep watching the show and hate that they get woken up every time there's a commercial because suddenly it got loud. But that's the FCC thing. Bree Roz comes in with her with her analysis of the trial in emoji form. Bree, I might need you to call in and walk us through this on the burner phone. I'm not sure if you're at a point where you can do that. But it taxes my brain. Let's see. Mom's money for the house. This guy paints a picture that money down equals house. Okay. Leave the plane for work. Okay. I can see New Year's in here. I can see the celebration for New Year's. Broken heart, mind blown. This guy sees Brian sees the phone, sees that they're hooking up, and he makes him mad. Goes to New Year's Day. They party. They're supposed to go to bed, but she's dead. So the next morning he doesn't know what to do. So he thinks about it. He searches for corn and how to dispose of a body, and when do you get the money? Then he goes to the hardware store, gets the tools, asks to clean up the DNA and the blood. He goes to the store, and he's seen on cameras. He buys some new furniture stuff. I'm not sure about the bath, but all the bottles of soap, the cleaners, and the DNA is found in the trash. We have video, and then he gets, the police find the blood. Okay, Bree, I think I got the gist of it. But that's the entire case in emoji form. If you missed it, there it is, Bree. It's fabulous, as always. All right. Let's see. Starboard, you had a question. I hate ads, and even more blaring ads. It reflects poorly on the streamer. I agree. Because of that, Starboard, I can't get rid of all ads, but I can get rid of ads during a live stream. Because of that, I get bombarded by YouTube. Like literally, they will email me, they will reach out to me. I'll have pop-ups on my screen telling me to send you ads, and I don't do it. I don't do it because I wouldn't want to watch court and have ads pop up. Now on the replay, YouTube takes that out of my hands and adds ads to it. The only way I could turn it off is if I demonetize the channel, and then YouTube still might do it. But if I demonetize the channel, then I can't afford to do what I do here, and I just that's not an option here. But during the live streams, we don't put ads in, and we try to just follow court as it goes. Let me fix the timer here because it moves around a little bit on me. Okay. There we go. And we'll pull that left side in just a touch, a smooch. All right, Bray did a great job with that. And yes, the corn made it in there. That's amazing. Premium is the best way to get around the ads. I will say that if you do have premium YouTube and watch the channel, YouTube does share some of the money you pay them for not getting ads with me. And so if you do that, thank you very much. I appreciate the support. I'm glad that you get to watch court with no ads, and thank you for spending your valuable viewing hours here. The squares are the rugs, but I pretty much got it, Bree. I'm getting better at reading emojis. Premium is the way to go. It's expensive. I realize that for some of you that premium's not an option. It's just not in the budget. And because of that, I do what I can just to make sure there's, what ads there are usually would be at the very beginning and at the very end. YouTube will do that. I don't have any control over that. But I try to make it great for everybody. The ad blockers, they work, but it's always a constant battle as YouTube tries to find ways around it. So eventually your YouTube breaks. So, but good. Thank you again, Whiskbrand, by the way. You were one of the gifters, the gifted memberships. Thank you very much. I appreciate that. If you consume a lot of YouTube, it's so worth it. I think it is for me, obviously. I've found that it's worth it, but I recognize that there are some people who the decision of discretionary spending of $12, $15 a month, it's the budget's that tight that there's not that room. So I'll do what I can for the rest of you there. Pam Graham, yeah, I don't get ads when RA is live, but if I watch replay, I get ads. And I can't change the replay ads, unfortunately. I've tried to talk to them and say, look, as a long-form streamer, okay, I realize there are people out there who stream for 10 minutes or 20 minutes, and that's their live, and they're done. Or even an hour, and they're done. And yeah, maybe a few commercial breaks during that would be similar to television watching, where you get a few commercial breaks, every 20 minutes or 10 minutes or something. If they do ads every 5 minutes on a long-form stream where we're here for 8 hours, you've watched hours of ads, and that's just not fun. It's not enjoyable. How do you keep the flow of the courtroom? And plus the placement of the ads is always terrible because we don't know what's coming up next or what somebody's going to say or when the break's going to be there or how long it's going to last. Since I pay premium on YouTube, that goes to YouTube creators too? Yes, it's divided up, Jade. It's divided between all the channels you watch. And basically they say that, I don't know what the percentage is, like how much of the YouTube premium money goes to the creators, but that whatever portion does goes to creators, they'll look at, a pie chart of all the channels you watch and divide it proportionally that way. So wherever you spend the most time, that's where the most support goes. Let's see. The prosecutor, and by the way, let me just say that I'm extremely grateful that that this community chooses to support the channel through gifted memberships, predominantly as the main source. Because there are people who can't afford to be a member or to pay for premium or something like that, but are very much just as important to the channel, have been around just as long, and I love that they get included that way. So yes, I do sometimes get a little emotional when I see a gift train like that, because it means so much for so many people who, for them, it just is an option at the time to do that. So I appreciate that. Thank you for thinking of them. Timothy says, you probably get about 90% of my premium then. That's awesome. Let's see. A Wendy, member for 16 months, says, love your work. Thank you. 16 months. That is wonderful. It wouldn't be the same without you here. I wish you could get Target gift subs like you can on Twitch. Oh, yeah, Target. I'm not sure if Target does. I know on Twitch, Prime does that as well. They give you like 1 sub a month if you have Amazon Prime. But that's Twitch only, and I'm not on Twitch. All right. Paul Mack says, getting my 2019 Camry detailed by a mobile guy. He must be good. It wasn't too bad, and he's been at it for over 2.5 hours. Wow, you might have a new car by the time he's done. Miss Kitty says, I gave up my cable TV, and now it went away. And mostly watch YouTube Premium, so was the way to go for me. Yeah, if you do have, like for me, I used to go out to the movies, right? I used to like going to the theater. For some reason, it's just not the same anymore. Maybe it's because all the good movies have been made, and I haven't had the desire to watch a movie in the theater in quite a while. For me, it's easy to say, if I was going to go out to the movies, it would cost me about the same as YouTube Premium for a month. 1 ticket, YouTube Premium, and for me, that's a good match. Wow, Wendy. Hey, Wendy just gifted 10 more memberships. Thank you for your generosity, and congratulations on your 16 months as well. That is wonderful. You were super generous. I misunderstood. Was that me or someone else? I pay like $25 for premium and can have 5 people on my account. I love it because I spend a lot of time on YouTube. I did also upgrade so I could share it with my family, mostly because Mrs. R.A. Watches me and a lot of other LawTube channels, as well as a ton of homeschooling related stuff, and she was getting ads nonstop, and it was terrible. I'm like, why are you getting ads? Let's get you on my plan so that you can not get ads when you're teaching school. I mean, we don't want ads for the kids during school, so they're watching a video about some topic. Let's see. Lisa Booker says, crazy 2-hour useless meeting. What did I miss? If in jury deliberations say 1 to 2 hours, guilty first degree. There you go, Lisa. You got your vote in. Thank you for that. We are in verdict watch. We are 16 and almost 17 minutes into that. The judge has said that she will give a 10-minute notice, which probably will mean that we will get a notification on Twitter that there is a verdict before there's a verdict. And I like it that way. Some judges just walk into the courtroom and that's when you know there's a verdict because they just came in. So we will have a little bit of a buffer time, about 10 minutes. If you do see something from a reputable source, and by that I mean typically it's going to be a news media outlet or a reporter who has been in the courtroom watching the case from the get-go, or a channel like Law and Crime, Court TV, Boston NBC 10, the Boston Herald, any of these established things that say we have a verdict. Feel free to shoot me a burner message real quick and say, hey, so-and-so just said this. We'll verify it. We don't like to play the music prematurely, but we do want some time just to gather the troops, so to speak, here on our end, and get everyone together and ready for that verdict to come in so nobody misses it. Bravo Chick comes with a super chat, says, rephrase, you can choose who gets your gifted sub on Twitch if you wish, or make it random. I wish we had that feature on YouTube. That would be cool. At any rate, take my money, love this community. Bravo Chick, thank you so much. Thank you. YouTube Premium is the only subscription I haven't canceled. I watch it all day and night. I sleep with the TV on. It's great company, especially if you're in a situation where you don't have a lot of family around anymore. As we're not there yet. Obviously, we're getting closer to empty nesters with nearly half the family gone. We've got some years ahead of us, and I'm looking forward to those being wonderful years. But it's made me think a little bit. There's a hole, right? People are missing. When the family gets together around the dinner table, there are empty chairs, and I've had to do some thinking about that. I'm not excited about that. I'm excited the kids are growing up and progressing in life and doing amazing things, but I don't like them being gone as much. I like them around. Luca says, first, hello to the best community and the best and kindest streamer here on YouTube. Luca, thanks for the kind words. I will try to live up to your kind praise. Scotch Mom, thank you for keeping an ear to the ground on this one. Second, says Luca, oh no, I missed the closings. We'll have to watch them back later. All right. Is there a third? Did I miss the third? Let's see. Let's see. If she's watching you on your premium shared account, does that mean you're making some money off your own account since it's being viewed via the premium service? I don't know if YouTube allows that to happen, but I don't see why they wouldn't. I'm basically paying $1 to get a penny back. I don't think YouTube would have a problem with that because they're getting the dollar side. What's the shortest deliberation time we've seen? I think we had, man, this is tough because my memory does not work very well like this. I don't know if I'm getting old and early onset amnesia. I don't know what it is, but I have a hard time recalling like the best of moments. I can hardly remember a case, even if you tell me somebody's name. I would say like 33 minutes seems to stick in my head. Who was at 33 minutes? What's the fastest verdict? I think it's around then, Barb. I think it's around, I thought it was under an hour. 34 minutes. It was probably one of what we call our court hopping cases that happened in a small trial where, we got to see the jury seated, something like Thurston, Washington, or Judge Brantley Clark, something like that. I don't remember it being on a large case with, like a week-long trial or something, having a short verdict like that. Sarah Boone was fairly short, wasn't it? How long was Sarah Boone's? Let's see. When you go and grab something to eat, we usually get a verdict. Well, I can tell you we're going to actually take a lunch today. And what I'm going to do is... Let's see, what time is it? Let me check the timers. Got to do the math on this one. YouTube changed they changed my view. Like when I'm monitoring my stream, now the information I need is on multiple different streams. And I'm not a fan of it. I wish I could switch it back because I can no longer see everything on the same page. Okay, we've been live for 4 hours. We'll probably take a break. What we don't want to do is pass the 6 hour mark on a single live stream. I lose some abilities as far as managing a video stream after the fact when it goes over 6 hours. And those are crucial for the channel. It's in case something goes wrong, I can fix it. And if something is shown that the judge orders needs to be cut out, I can cut it out. But after 6 hours, I can't. The only option would be to just take down the whole stream. And I don't want to do that because there are a lot of people on rewatch that catch up. So we're probably going to do a lunch break. Give us another, it's 12:46 right now. Give us up to about 1 o'clock. We'll take a lunch break. We know we're not going to get a verdict in that hour. I'll keep the timer going, and we'll have a portal over to a new channel where we start. Maybe even we'll start it with the timer going just on a placeholder, so we can come in when something comes back. So you'll be able to see the timer, and I'll just be able to turn it on when that happens. Does that work? I don't want the mods to feel like they have to closely monitor chat the whole time. So just everyone be good, and we'll make it happen. Let the mods get a break during the lunch hour. What verdict has shocked you the most? Barb, this is a great question. I would say the one that I had the hardest time settling myself to the outcome might have been Ayden. And that was a difficult one because there was a lot of clamor. There was a lot of voices speaking about that one. Ayden was the officer that went to the backyard and shot, was it Tatiana Jefferson, through the window in her own home. I struggled with that, just mostly because he made some mistakes, but he didn't show up there looking to shoot somebody. He was literally responding to help. He was there in a position of help, and the information that he had got had led him to a situation where he was, I believe, under the impression that this was a dangerous situation, and it was just bad information. And I struggled with that one. It's a difficult one. Ashley Banfield for me. The Waffle House shooter. I was torn on the Ayden one because I think for me, I would have felt better had Ayden been found not guilty in the criminal trial and culpable in a civil trial. You can't restore the family, but basically gave compensation to the family, and it would probably be substantial, maybe even life-ruining compensation for Ayden, because there were mistakes made, but I just didn't see that they were criminal mistakes. That was a tough one. The first one I was shocked at, though, was watching the Arizona AR-15 shooter, the guy that flew down to buy property in Arizona and stayed the night at the guy's house, and the guy came in drunk and he shot him in his own house and defended himself. Sat in prison for 2 years, or jail for 2 years. He said he was innocent. That was the case where the prosecutor gave him the gun and had him reenact the whole scene of how it went down. And he's like holding the actual gun in court. They've taken it out of the box and everything. And the prosecutor's pretending to be the victim. And as they're reenacting the shooting, then the judges, the bailiff's like, "Can we just check and make sure there are no bullets in that?" That was wild. That was a wild one. Let's see. Yeah, AWOL, I hear you. I see the other side. But I just can't see the criminal intent with the police officer. I don't see it. I see a terrible situation that unfolded with bad information and poor training. But it's a tough one. Qualified immunity needs to be revoked. I think it needs to be limited. Not all crimes require intent. Some are negligence or recklessness. I agree. That's why we have the lesser charges. I think it was overcharged in that one. Dean Cummings, yeah, he was the guy. He was the guy with the reenacting the event, and it worked. He took the stand, and I was saying, no, that's the worst thing you can do. He took the stand in his own defense, and it was amazing, and the jury agreed with him. He won. Super Nanny just gifted a membership. Thank you very much, Super Nanny, adding to the long string of gifted memberships we've seen today. Laurie says, I swear YouTube can tell when I'm at my computer. I have to lie down periodically, and the second I lay down, an ad runs, and I'm not near enough to hit skip. I have to decide to get back up or skip or not. You need a wireless mouse you can take with you. Dewijo, I don't know how to say your name, and I apologize for that. This is my first case watching, all right? I really hope we get a verdict today and don't have to wait all weekend. I'm with you, and welcome. Welcome. It's great to have you here. How often do nurses make mistakes that end in deleting someone? Why are nurses given more grace than cops? I can try to answer this one. I think we have a lot of nurses here as well. A gun is rarely used on someone to help them, right? It's really got one purpose, and it generally is not to help the person it's pointed at. In nursing, however, medication is administered to help, and it can also hurt if done improperly, if in the wrong amounts, the wrong time, too much of it, and mixed with something else. There's a lot of things that can go wrong, but generally the nurses are seen more as helping, where the police are intervening in like a forceful way. Let's see. We rent our Airbnb. It's not actual Airbnb, but we rent our detached residence on a property to nurses. So we have traveling nurses that live here basically 24/7. It doesn't mean we have a live-in nurse that we can just call anytime we want. We can't do that, unfortunately. It would be nice, and it would be a lot cheaper than going to the doctor. But it's interesting to see that lifestyle of nurses and getting to know them a little bit and how they work. It's hard work. They get paid well, but it's hard work. We do have case summaries on the website. Topmark Media. Topmark.media is the website, my parent company, which I own. The Baldwin trial was insane. Like, that was some real life mimicking art stuff. I couldn't believe what I was seeing. Mr. Opertorso, that the first trial in that whole shooting situation, the Rust movie trial, where what's her name? She was found guilty. It was a short sentence. Basically, by the time she was able to appeal, their sentence was over. But she was found guilty, and then he was, the case dismissed with prejudice because of the actions of the prosecutor, which basically affected the first trial as well, but a little bit differently. Yeah, that was a crazy one. It's hard to look at that and say, well, it sure helps, not say, well, it sure helps to have money if you're prosecuted with something, because I don't think Hannah would have got that same benefit that Alec got. Jendabomb, welcome to the gallery. Did I say that right, Jendabomb? Welcome. It's wonderful to have you here. You're one of us now. You can never leave. You can see by your name you have a brand new courthouse. It is blue. I'll drag it across the screen. It'll fly back. That courthouse changes color with each month you're a member. You can see some of our people here, like Red Pen, have this beautiful, I call it a pink courthouse. That's the 3-year mark, I think. That's the 3-year mark. We have some people who've been here a long time, and I'm very grateful for that. How many likes do we have exactly? Right now we have 1,166. Camilla. 68. 1,168 now. Letitia Stout gets my most disdained defendant award. She was a tough one to listen to, for sure. No, it's 2 years. Okay, 3 years is where you get the purple, right? 2 years for pink. I think 3 years for purple. I think next month we'll start seeing purple membership membership icons. AWOL says, I give medical professionals the benefit of the doubt. I don't extend that same feeling to state actors. I guess I read too many books and had been traumatized as a 9-year-old by a badge. That might be it. But I appreciate, AWOL, your vantage point. I would say that I can generally predict where you're going to come in, and I think it's not a bad thing. I'm not saying that I can guess where you're going to be. You hold the state to the high burden that they're intended to be held to in every situation. I think you would make an excellent juror, and even though we disagree sometimes on the verdict, if I ever go to trial, I'd like you to be one of the jurors. I'd love it for you to be one of the jurors deciding my outcome. I Rescue Dogs member for 34 months. OG. Original goat here. I can't wait for verdict music. I'm so close to the next Kohler courthouse. It is very, very close. Thank you, I Rescue Dogs. It's wonderful to have you here. Would not be the same without you. 3 years is red, 4 years is purple. I thought it was 2 and 3. How long has it been? When was the how long have we been doing this? I don't even know. Since Daryl Brooks. When was the Daryl Brooks trial? That was our first that we really live streamed like this. I was in chat on this channel talking about court cases before then, so some of you might have seen the Recovery Addict channel, say like on the Johnny Depp trial and things like that. But we need to see the Febreze video. I love that video. Oh, it's out there. You can find it. Look on Rob's channel. He's got it. Here in Middle Tennessee, the court just convicted a sheriff's daughter for child abuse 20 years. Not sure, but I think it may have been in Judge Wolf's court. Wow. Judge Wolf does stream on YouTube as well. Let's see. Who am I and where am I? This is me. I'm getting older, and memory is a tough thing. I have to write more notes nowadays. Rob has been busy. His law practice has kept him hopping. So I hope to be able to see more from Rob. Maybe during the holidays would be great, although that's good family time as well. Let's see. Time-wise, we're at 34 minutes into deliberation, and as we have come within that 10-minute window of 1 o'clock, we're going to go ahead and take a break. Give me a minute to get the afternoon stream and the portal set up so that you will have a place to land on the other side. This is Verdict Watch. Day 10. I've got the vibe that we are getting a verdict today. And I do think that after lunch, if you have the opportunity to be back before lunch is over, you might want to do that. I just feel like this might be one where it could be fast. I mean, it could be fast and they come back with second-degree murder. I would not be heartbroken if they came back with second degree. I would feel, and I think many people might agree, I would feel that there would be an injustice if they came back with not guilty, because in Massachusetts, as in many states, murder is they're not just trying for murder 1, and if they fail, they can come back with murder 2. It's that would be double jeopardy. Once you've tried them for murder, if they're found not guilty, they're scot-free. And I would feel that he got away with something major if they come back with not guilty. So, but I don't feel that he must serve life without parole. I'm not that guy either. I usually don't get into the sentence that way. If anything, I tend to lean to the perspective that people, even people who commit heinous crimes, can change. That there is, I have to believe that, because the system we have literally is designed in part to rehabilitate someone. And if it does not work, if people can't change, then we should just go with lock everyone up forever, or death penalty for every crime. I believe that people can learn from their mistakes and make something good of something that was bad. And most of the time that involves paying it back. Josh Hutchins comes in, member for 22 months. Fabulous mod, great friend of the channel, and an attorney as well. This milestone message only says 22 months, but love it here. Most days, especially when chat behaves. Josh, you are in fact an OG. Thank you very much. Our moderators are fantastic. I love that I get to see them interact with each other and how well they work together. They're all amazing. Have you thought about putting a shout out on Discord to say we have a verdict for those that have stuff to do? Jan, believe it or not, I don't really have a Discord channel. There's the As the Gavel Drops Discord channel, which has been a friend of the channel since day one, who does post some things and updates about us when we're going live. They host documents and files and discussions and everything else on every single court case we've ever followed, as well as a billion more. So that's sort of been the place. I can't recreate that. I definitely can't do it any better than they do. I tend to focus where my strength is, which is on the tech side, on the audio, on the video, and bringing you the best court watching experience that I can. And other than that, I'll try to use YouTube for notifications when necessary. Barb says, is there a case that never leaves you, that happened in the past that you can't shake? Yeah. Barb, like I said, I have this wonderful thing called a bad memory. And I used to think it was a curse. I had great eyesight and a bad memory. But weirdly, I can watch a very difficult court case during the day and conclude for the day, do our outro, shut down the live stream, walk out and talk to my wife about, the kids or whatever plans are for the weekend. And she'll ask me something about the day, and I get this like deer in the headlight look, like, what were we following today? What was that case? I don't know how my brain does it. I'm not sure if it's a sign of trauma or something else, but I just compartmentalize some of the difficult trials we've sat through and keep that separate from my regular life. So I don't really have one that haunts me, right? And maybe it's because we're just observers, right? If I was a player in the courtroom, if I was a victim, if I was even a juror member that made that decision, that would probably be very different. But I don't, aside from those, just what I mentioned, ones where I just didn't feel the verdict fit, I don't have that. Thomas, my good friend and podcast partner, member for 34 months, says, I'm just here for the garlic. Yesterday was the garlic. Thomas, you missed my summation this morning, first thing about my wife's response to the garlic. And I even shared a story about a kiss, my first kiss. So you can go back and clip that if you want. But that was fun this morning. Thomas, thank you very much. Yesterday was a blast. If you miss, we do a podcast every Thursday night. Sometimes we move it. But every Thursday night at 8 p.m. on this channel, it's live just like this. And we just have some fun. Sometimes we'll talk about court. Sometimes we just talk about news stories and funny things going on in life. But really, it's just a time to hang out and sort of see each other outside this true crime, the true crime colored glasses that we see each other in and day out. So good fun. Thomas, thank you very much. You have intentional memory and short-term memory. It's good to compartmentalize. Well, the short-term memory is kicking butt right now. It's doing great. All right, I have made I am making right now the thumbnail for the afternoon Verdict Watch session. My plans for Verdict Watch is to keep the timer going in the corner like it is right now, but also possibly doing a little bit of court hopping if you haven't done that with us before. There are a lot of courts. There are dozens and dozens of courts around the country that stream live to YouTube. We've basically become acquainted with some of our favorite judges and courts and jurisdictions, and we do that. So we might jump straight from this murder trial to a landlord-tenant issue in Michigan, or a traffic ticket issue, parking ticket in Royal Oaks. We love doing that, but please join us for that. We will keep an eye on this case. We have all this on lockdown, so if anything happens, you will hear it here. You won't miss a thing when we jump back to the verdict the second it happens, if it comes in today, with verdict music as well. So please do join us for that this afternoon. We'd love to have you stick around for that. Just getting the portal route built. There we go. Edit. Customization. Redirect to the afternoon stream. Now it's done. There we go. Have you ever thought a case was too much for you to handle? Yes. Yes, Barb. There are cases involving children that are too much to handle for a number of reasons. First of all, the courts generally side with closing down access when they're child victims, and it's this community, as you can imagine, looking at just the age of the community, most of us are parents. Most of us have kids of our own. You know how hard it is for a police officer to respond to a scene where a child is, the age of their child is there. Most of us put ourselves in that situation, and it's difficult on some of those cases. Gannon Stout, terrible. It's a case we followed, but it was just a terrible case to sit through, and so we do take those in very limited numbers and we space them out. But we try to do things that we try to stick to just regular old murder, which we seem to all agree on. So tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. It will be just in moments. I think I'm going to just have my logo. It'll look like this on the screen, but without chat up there. And without my face, so it'll look like that, and we'll just have the timer running. Yeah, it'll look like that, but the timer will be running. That's how it's gonna look. Like, nope, that's not it. That's going back on 3, 2, 1. There you go. It's gonna look like this. All right, we'll see you guys after lunch. I'll have the timer up, and we'll be back in just a minute. See you guys. Bye bye.